Just in time.
Thank you. That is your first name, isn't it? Ron. No,
What? Sure. Let's call this meeting to order at 4:07 p.m. Please call the roll.
Matthew Kate. Matthew Kate present. Lila LaHood.
Present.
Lila LaHood present. Josh Wolf not present. Luan Tesfaye not present. Rodman Martin.
Present.
Robin Martin present. Frank Canada.
Present.
Frank Canada present. Chris Highland.
Present.
Chris Highland present. Matthew Yankee.
Present.
Matthew Yankee present. Fiona Hensey.
present.
Fiona Hensey present. Chair Wolf.
Present.
Chair Wolf present.
I think Member Tesfaye is coming up. I just got a text that she's having an issue at security.
Yeah, okay. She also said to me that she might have to leave by 6 o'clock, too.
Okay, that's fine, as long as she's here. Okay. Call the first item.
Roll call, and agenda changes.
Agenda changes.
Yes, Betty Mackey let me know, as you saw the email, that she has granted the respondent his request for continuance. So we will not hear from either party today.
From
I'm sorry. Betty Mackey,
Betty Mackey.
number 18067, I believe. Mr. Beck had requested about 2 weeks ago.
Right.
A chance
So
to
she
continue.
grant- she
She
said
said
okay.
it, yeah, like very late Friday afternoon.
All right, so can we have a motion to, let's have a motion to continue that item. We can get it out of the way right away.
So moved.
Moved by Member Kanata, second by Member Kate. Any discussion, any public comment on the continuance? Seeing none, can we take this by acclamation? Seeing no objection? Okay, let's call the next item.
Item number 2, approval of minutes from the Sunshine Ordinance Task Force January 2nd, 2019 meeting.
Okay, any changes, adjustments?
Yeah, I have one.
ahead, Member
Item number
Yankee.
8, you have me voting twice. I think you're missing Mr. Kanata.
Yep, you're correct. Thank you for pointing that out.
Bet.
Any other changes, adjustments, edits? Seeing none. Is there a motion?
Make motion to approve.
Moved by Member Yankee,
All second.
second by Member Hensey. Public comment on the minutes. Seeing no public comment, can we take that by acclamation? Seeing no objection, the minutes are approved. Next item, please.
Item number 3, file number 19005, Supervisor of Records Report 2017 and 2018.
Welcome.
Good afternoon, Chair Wolf, honorable members of the task force. My name is John Cote. I am the Communications Director for the City Attorney's Office, and I'm here this afternoon to present 2 Supervisor of Records annual reports for year 2017 and for 2018. You have the reports in your packets, but I'll provide a quick summary, and then I'm happy to answer any questions you may have.
Hey, just before you get started, just
Sure.
recognize Member Tesfaye and Member Josh Wolf arriving at 4:10. Proceed.
Thank you. So for the 2017 annual report, there were 14 petitions total to the Supervisor of Records. Of those 14, 5, the department produced responsive records, and the petitions were then closed. Another 5, the department confirmed it had no responsive records. For 3 additional petitions, the Supervisor of Records issued a determination finding that the department had properly withheld or redacted documents. and the remaining petition was outside the scope of the supervisor of records jurisdiction. Now, there was also 0 court decisions during that time period regarding determinations by the supervisor of records. However, there was 1 court decision interpreting or applying the Sunshine Ordinance, and that was a case by the name of Bayview Hunters Point Arts Council versus the City and County of San Francisco. In that case, the California Court of Appeal considered whether the open meeting requirements of the Sunshine Ordinance applied to a panel of individuals that was created by a city employee to review responses to a request for proposal. And the court found that the review panel was not subject to the Sunshine Ordinance's open meeting requirements. And then on to 2018.
Can I stop to ask?
Sure.
Is there any detail to that as to what the judge's decision was? Is that
There's a fair amount of detail. It's included
in your report?
In the report,
Okay.
and I'm happy to highlight some of it for you if you'd like.
Just find that a little interesting because the ordinance specifies bodies that are created by city employees and specific city employees, whether it's the department head or someone subordinate to the department head. It makes a difference.
So it certainly specifies department heads. However, the court found that there was no evidence that the review panel had been created at the initiative of either the Arts Commission or any policy body, and the employee was not a department head.
Okay. Continue.
Sure. As for the 2018 annual report, slightly fewer petitions last year. There were 8 petitions total. 3 of those, the department produced responsive records, and the petitions were then closed. 1 petition the department confirmed it had no responsive records. For 3 other petitions, the supervisor of records issued a determination finding that the department had properly withheld or redacted the records, and 1 petition was found to be outside the scope of the supervisor of records jurisdiction. Again, there were 0 court decisions issued regarding determinations by the supervisor of records. And again, there was also 1 court decision interpreting or applying the Sunshine Ordinance during that period, and that was the case of SF Urban Forest Coalition versus the San Francisco County Transportation Authority. And in that instance, the nonprofit had sought a court ruling finding that the County Transportation Authority is a city department subject to the Sunshine Ordinance. However, the court denied the petition and found that the County Transportation Authority is an agency of the state and is not subject to the Sunshine Ordinance. And with that, I'm happy to take any questions you may have.
Members? I have a question.
Sure.
So, had any members of the public come to your office seeking determination of requests that they had made on records denied by other people other than what's in the city attorney's office for determination whether those items were public or not?
I think I'm following your question, which is,
Go ahead.
did members of the public come to the city attorney's office and ask for review of records requests that they had made of other departments? And
As the supervisor of records, okay, there's a specific provision in the Sunshine Ordinance in Section 6721 that actually allows members of the public to engage the superintendent of records and to request determination, as we do here in discovery, of whether the records that they are requesting are public or not. And actually, the superintendent of records can make a determination, like we do, to compel those that are withholding the records to produce them.
Right. So I believe those are all the petitions that I just referenced.
Okay, but it sounded like you were saying that that you weren't withholding.
No, these are other city
Other-
agencies.
okay.
None of them involve petitions involving the city
Oh, okay.
attorney's office.
Okay. Okay, that's right. Then I misheard it. Okay, thank you.
Sure, no problem.
Any other questions? Okay, thank you.
Sure.
We'll
you.
receive that into the record. Is there any public comment?
Good afternoon. I'm Peter Warfield, Executive Director of Library Users Association, and I see a number of new faces and a number of old ones since my last visit. First of all, I would like to ask whether you would please speak up and ask your folks to speak up here who are giving reports. It's a little hard to hear sometimes when the volume is low. With respect to the Supervisor of Public Records, I appreciate the questions from the chair. Section 6721D for dog says if there's a problem with the custodian of records giving a requester information, they can petition the supervisor of records, which is the city attorney, for a determination whether the record requested is public. The supervisor of records shall inform, I'm reading now, shall inform the petitioner as soon as possible and within 10 days of its determination whether the record requested or any part of the record requested is public. And it goes on from there. Now, in past years, I have asked for there to be clarity with respect to the 10-day provision. And I don't see from page 14 of your agenda, which is the 18th annual report of the Supervisor of Records, it's not clear to me. For each item, there's a date petition received and then date of determination. But in some cases, the date of determination, it says petition closed on such and such a date. So, for example, the first petitioner, date petition received January 13, 2017, date of determination, February 22, 2017. That's well more than a month afterwards. And if that's when the supervisor of records made a determination, they're well overdue. I went to the supervisor of records early in my career as a library user advocate because I was relying on what looked like the speed and the ease with which a decision could be rendered. And I inquired after about 7 or 8 days. I called up and said, what's the status of my request? And the answer was, what request? So they scrambled around and got back to me and said, oh, we just found it had slipped somewhere behind something or was under a pile or something. And then the guy who answered chuckled and said, but we never meet the 10 days anyway. And I only got my answer long after the 10 days. And it was very distressing because I wanted an answer promptly. You know the phrase, justice delayed is justice denied. I don't remember how much longer, but the laugh and the comment, we never meet the deadline, was quite shocking to me. And they did exceed the deadline. So here we have more than a month, and I've asked in the past that these reports be reviewed for whether they satisfy the basic legal requirement of giving the requester a response in 10 days. Now, some of these seem pretty prompt. I don't know what petition closed means. I don't know in plain English what that means. Was that the date the determination was given? There are numbers of things where it's more than a month or about a month. Number 14, December 19th to January 10th, that's more than 10 days. So I would ask you to review the timing and insist on finding out why, if it's not correct, why that happened, and not accept this if you don't have clear answers and you're not satisfied on behalf of the public. Thank you.
Any other public comment? Mr. Cote, I have a question. And I guess this is just curious for me. On page 16, number 8, The petitioner was David Pilpel. The department was MTA. The petitioner requested a statement as to the existence, quantity, form, nature records relating to Upper Market Street safety pursuant to Section 6721C. Your determination was that it was outside your jurisdiction. How is that?
So for that specific case, I would have to go back and do some additional research.
Okay.
I personally am not the supervisor of records. As you see, the memo was prepared by a colleague. And so for specifics on that, I would need to check. And so if you have a specific request that you would like or additional information that you'd like on that, I'd request that you just submit a request in writing to me or to the city attorney's office general email.
Okay.
And we'll get a response to you.
Yeah, because there are a couple other ones, like even the next one, Office of Community Investment and Infrastructure, which sounds like it's under the mayor's office. It's also notated not subject to supervisor of records jurisdiction.
So in the case of OCII, that is essentially the successor agency to a redevelopment agency. Mm-hmm. So it is a state authorized local entity. It's not a city department.
The city makes appointments to it.
I mean, that was the determination of the supervisor of records.
Okay. So not subject to Sunshine? Not subject to the California Public Records Act?
No, that's not what we indicated. We indicated that it was outside the jurisdiction of the supervisor of records.
Okay. Thank you.
Sure thing.
That'll be an interesting subject to research for us. Okay. Thank you very much. I appreciate it. Yes, please. Okay. Let's call. So we'll accept that into the record. Can we take that without objection? I'm just going to take a general acceptance. Okay. Thank you. Let's move on to the next item, please.
Item number 4, file number 18012, complaint filed by Dent Tedeschi against Lori Mazzola, City Hall Building Management, for allegedly violating Administrative Code Section 67.5 by restricting access to all meeting of any policy body in City Hall.
Okay. I believe this item was continued.
It's the one for rebuttals only, I think.
Right. Okay.
Continued what?
I'm sorry? Go.
Continued regarding what?
This case was continued because there was an incident where one of the parties, the petitioner, had to leave.
Okay.
And we couldn't continue and didn't know what the petitioner wanted us to do.
Was this also the item where we had requested legal counsel advising us on the ADA?
Yes, it was.
I just wanted to let the group know that I have a lot of hesitation and concerns about our authority to interpret the ADA after I read what we had received. So I just wanted to put that out there, that I have a lot of concerns about. I was looking back at the Sunshine Ordinance itself and whether we have the authority to interpret the ADA. So
Our focus here is on barrier of access to meetings. And if somebody's being prohibited from access to a meeting and it was based upon the ADA, then we have to determine whether that policy was correct or not, to determine whether there was non-compliance with the Sunshine Ordinance based on barrier. If the ADA allows for that restriction, then that will help us to make that determination. Our focus is on the barrier to a public meeting. Okay. All right. So where we left off on this was we were in the middle of questions and answers for either party, and we were approaching rebuttals. So we're going to pick it up from there. But I want to give an opportunity for Member Hinsey and I to report on what we had decided to take up on trying to find out what the issue was. One of the reasons why this ended up being continued is because the actual detail the subject matter of this particular case was actually happening in real time that caused the petitioner to have to leave. The same exact issue. Okay, so that's why it becomes a little bit complex, but it also one thing will also help deal with the other thing at the same time. So Member Hinsey and I spoke on the phone. We talked a little bit about who should we should ask. We reviewed some areas of the ADA in order to understand how to ask the questions, and I believe we decided that we would engage disability rights advocates, which is pretty much the premier Bay Area, if not federal, law firm that represents people with disabilities in civil rights cases. And so I know Member Hinsey sent them a message. I don't know if she got a response.
I've not yet received a response, but I only sent it late Friday afternoon. So I would expect that I'm going to try a couple more avenues with them, and I would suspect that I would get a response within the next couple weeks or so. So just bear that in mind as we move forward.
Okay, great. And I just want to give opportunity for our legal counsel to add if there's anything to add based upon the memorandum that was already sent.
Go ahead.
I don't have anything to add other than when Mr. Cola circulated.
Okay, thank you. All right, so
I brought hard copies of that too, in case
Okay.
anybody needs to read it.
great. If you know, yeah. So if there's any, member Josh Wolf, so let's pick it up where we left off, which was during clarification Q&A.
Well, this is actually more a point of process issue, which is if we're expecting additional information about the legality of it, should we avoid actually making a motion today?
I will leave that up to you folks, or up to us. I would like to at least finish the process
Yeah.
first and get hear what the rebuttals are, and then we can have some discussion about what we want to do in process. How's that?
Sounds good.
Okay. All right.
Chair,
Yeah.
question. Going back to what Member Tesfaye was saying, I think we're okay with just looking at the very simple idea of a barrier to entry and moving forward on that, because that is within our purview from what I understand.
Right.
But I understand you don't probably want to take a motion on that until we've heard rebuttals.
Right. I want to finish the process first, so when we come to the point when we are to come to some conclusion, then we can determine how to dispense with this case. Okay?
Sure.
So are there any further questions, clarifications you have for any of the parties? Member Kate.
And this is kind of, I mean, I know it is kind of the tricky part where we've got to try to basically find whether or not there was a violation of the ADA in order to determine whether there was a barrier to access to the public meeting. And I mean, I'm looking at the note from the DCA on this about whether we have to address the criteria of whether the service animal is under control. And maybe there's something I didn't quite follow last time, but as I've been thinking about this, I think not only, I think the under the control is definitely something we have to consider, and we've heard, I think, some about that, but another component of the exception to the leash requirement is whether a leash usage would interfere with the service animal's performance of its tasks, or whether the disability renders the use of a leash kind of impossible or impractical. And I think for me, those are that first step, I guess, is what I need to hear more about, is whether whether the exception, the first stage of the exception to the leash policy applies. So whether the leash interferes with either the service animal's performance of its tasks or whether Mr. Tedeschi can't properly use a leash. And I think for me personally, I think the under control issue is pretty well established. I personally don't think there's any issue there. I think under control voice command is I think pretty readily established from what I've seen and heard. It's that first part that I have questions about.
Okay, so this sounds. I'll take that as a clarification question. I would like to reserve any more discussive comments as part of debate as we try to come to some conclusion, so we can hear from the rebuttals, because there may be some more information that comes through rebuttals. So are there any other clarifying questions you need from the parties at this point? No. Okay, so let's hear from rebuttals. We hear from the respondent first. Mr. Gavin.
Good evening, Chair Wolf and Commissioners. Thank you for holding this hearing today. I just wanted to reiterate that building management did contact the Mayor's Office of Disability on the day in question, and the counsel from the Mayor's Office of Disability led to the conclusion that either the service animal would be on leash because it wasn't apparent that the acts were necessary, a leash, off leash was necessary for the acts, but also the Mayor's Office of Disability mentioned that if it was not apparent that the animal was under control, the individual may be permitted to enter without the animal. So there were options given to Mr. Tedeschi to enter into the, I believe it was an MTA meeting he was seeking to go to. And therefore, based on the information given to building management from the Mayor's Office of Disability at that time, those decisions were made. And again, following up, the city attorney's memo regarding the issue also reiterated these 2 points: under control or the animal's tasks are prevented by a leash. And that was dated April 13th of 2018 after the fact, but just kind of reiterated the advice that the building management received from the Mayor's Office of Disability. I have no further information to give, but happy to answer questions.
Thank you. Is that we're doing rebuttals here? This isn't at the beginning of. We're picking this up where we left off. Okay, Mr. Tedeschi.
Good afternoon, task force members. I appreciate your time as always, and I appreciate you. I've listened to the. I hear the struggle that you have within this whole case, and I appreciate the time that you've taken. It's pretty simple to me. Here is what the Mayor's Office on Disability said at the time regarding this case.
Anybody else in support of the? Good evening, everybody. Can you hear me all right? Yes. I'm Nicole Mann, the director of the Mayor's Office on Disability, and I would like to say that the question at hand is whether or not
Sorry, buddy.
What is the access to the public meeting? The position of the Mayor's Office on Disability is we provide technical advice to whatever questions were asked by our city and public colleagues, irrespective of who the question is referring to. We provide technical advice, and then our colleagues can choose to follow it or not. We do not have the capability in a moment like that to make a judgment about whether or not an animal is effectively under control. And in this particular situation, we rely on our Sheriff's Department colleagues for that. That is part of their job. So I we feel like, as the Mayor's Office on Disability, we provided appropriate advice in this matter.
Thank you. Just point of clarification, method that you would use.
So again, this is all about under control. This is about if to decide for the city building management, they would have to actually show you how Rosie was out of control in that particular situation. They haven't. They have brought no evidence that she was out of control. The issue regarding the leashing and my disability, I have both a physical disability as well as a mental disability. Through my experience, I have had challenges with using a leash specifically that relates to my disability. I don't know how else to get that across to you. My experience has been that because of of my service animal's breed, people are afraid. They make sudden movements as I'm walking. I go through different security protocols. So the issue regarding the front entrance and the metal detectors, it's pretty simple. If I am having to have her on a leash and go through security, I'll go through more checks. I go through exhaustive questioning. So in order for that not to happen, I don't use a leash at that point. It's very simple. I put Rosie back on the leash if it's once I feel I'm safe, once I feel that having her on a leash will not in any way jeopardize my safety or hers. Very simple, and that's about it. They have not showed anything to you that she was out of control. Main thing is under control. As long as the animal is under control, they can be without the leash. If it's for the safety of the owner or the animal as well, and I get to choose that. Nobody else does. But the caveat is I have to make sure she's under control. I've done that. That's it.
Thank you, Mr. Dessa. Okay. Members? Vice Chair Hyland?
Would it be too simplistic just to propose a motion for violation of 675 and then unpack from that side? I mean, to start with that concept that there was, a denial to entry to a public meeting.
67 what?
675. That's what's referenced in the...
Okay. Because I'm looking at 6713 as being kind of really what this is about. Just read the first sentence. No policy body should conduct any meeting, conference, or other function in any facility that excludes persons on the basis of actual or presumed class identity or characteristics, or which is inaccessible to persons with physical disabilities, or where members of the public may not be present without payment or purchase. So creating a barrier, as in 67.5, is also creating a level of inaccessibility to a person with physical disability if their service animal is required for that.
Can we amend Vice Chair Hyland's motion to include that?
Absolutely.
Yeah.
So I feel like they're both applicable.
Happy to do that.
So
before I put the motion out there, what I'm saying is the group happy with us going down this road saying...
Are you asking for a straw poll?
I can propose a motion. We can see if we can get a second. We can go that route. I'm just trying to do it the cleanest possible way. because it seems to me that, if it affects 675 and 6713, perhaps the ADA stuff comes behind that. I mean, if we just on a very simplistic level, if these two things have been violated, maybe that's all we need to do. I'm hoping. Could it be that simple?
I just want to pose a little devil's advocate to make sure that we're a little bit circumspect on this. The question then becomes, we're still coming to the question as to whether the city had properly advised parties that made subjective decisions to restrict access to Mr. Tedesca because of his dog, his desire for his dog to be off leash under his rights, civil rights under ADA. We can put forward. You can put forward that motion. I would say I hear you suggesting it, okay, but I'm wondering if we've met that bar yet, and the reason why I'm saying that is because between reading and now I want to be conscious and cognizant of Member Tesfai's warning for us not to interpret the ADA per se, and that's why Member Fiona Hinsey and I had trying to engage a third-party expert, subject matter expert in the matter. And frankly, we could also, if you want, we can engage U.S. Attorney's Office also.
Yeah, we have other options.
Yeah, we could do that too, because ultimately that's who actually adjusted the guidelines in this decade. But my concern is the difference between the actual verbiage in the ADA and their frequently asked questions page, because they give some definitions with regards to, and reading in that is somewhat a little, it's not well written, because it says one thing in one sentence, and then the next sentence it kind of expands on that a little bit more. So it makes it for me, it makes it a little more confusing. And I just want to remind everybody that we have a specifically designated seat for a person with a disability on this body for this particular purpose. Okay? Because this is such an important situation, because we have old buildings or historical buildings that are not required to be ADA retrofitted, for whatever reason, or for financial hardships or what have you. So I just want to throw that out there. Member Kate.
I think, there are two different ways, and I think this is maybe what Member Highland's getting at. There's two different ways to kind of analyze this problem. One is ADA-based and saying, did the city violate the policy or the law of ADA and the regulations, and thereby in that violation restrict access to a public meeting? You could also say, set aside the ADA entirely, and basically this comes down to like a policy decision in a sense, I guess, of saying, should the city allow, I don't know if it would go just to one particular complainant, but people in general who have voice control or other control over whether it's a service animal, which is an ADA thing, or any pet, any dog that's a support animal or a service animal with or without a leash. You can analyze it without reference to the ADA, I think, and say the city can be more permissive. And that, and the determination of the vote that a failure to be so permissive and thereby preventing someone from entering a public meeting is a violation of the Sunshine Ordinance. That's another way to go, another way to look at it. And whether it's a motion separately based on an ADA violation or a motion separately based on irrespective of the ADA, I think it would still be a 67.5 or 67.13 violation if the members so felt that the more permissive policy or the ADA served as the basis.
Right. May I respond to Member Kate? I think he's explained my position better, and let me please let me recognize you, because other people have their hands up. But go ahead.
Finish your thought.
So that was where I was going. And actually, in rereading 675 and 6713, I'm almost tempted to make a motion just 675 alone, just a pure barrier to entry, go down that road, because 6713 talks more about disabilities, and then that maybe opens up that discussion. Maybe look at these as two separate paths. That I'm just trying to suggest, is that a more simple way of doing it?
I would just suggest, as a matter of process, put it all out on the table as part of debate, and then let's see what bubbles up in conclusion for somebody to make a motion. Member Josh Wolf.
I sort of see it in the opposite direction. I think that 6713A, with its language that explicitly speaks to, is inaccessible to persons with physical disabilities. Because he is not allowed to bring his service dog in the way that he needs to, that makes it inaccessible to a person with physical disability. So I think the narrow tailor of 6713A is actually better, because it actually does address that access issue specifically.
Okay, a couple of points that come up for me is in just reviewing some of the documentation and the testimony and taking from the ADA's fact sheet, they have a passage that says, with regards to leashes, unless these devices interfere with the service animal's work or the individual's disability prevents using these devices. So the question then becomes for me, and this is kind of the crux of the matter, is who determined whether the leash would interfere with Mr. Tedeschi's ability to be in the building or not, and whether that was appropriate for that person to make that determination. The way I read it, the ADA is really about the person who has the disability, and there's a very narrow area for a third party to make judgment, unless it's absolutely clear that the service does not match what the apparent disability is. And lots of times there's invisible disabilities, which makes a whole nother layer to that. But before I get to you, Member Kate, so that would be my first question, is who determined this subjectively? And then the second one would have been, I don't think this is a question we asked, has the city ever allowed a service dog off leash in the building or in any public building? And under what circumstances was that? And the second part, under what circumstances, is really kind of just of my own curiosity. But really it's just, have they allowed any service dog off leash? Yeah. That would be a question I would have. Member Kate, then Member Josh Wolf.
Sure. I spent a lot of time before kind of really letting it sink in that the city, by issuing the tag that it issued, had basically accepted and made the determination that Rosie is a service animal. And I think that kind of, I had spent a lot of time wondering before that sunk into me whether or not we were dealing with a service animal, because of the same question you just raised about who decides. And so I did a lot of research. So now, setting aside the service animal designation, which I think the city is, I want to say stuck with, I was looking into how that gets decided. And it's typically someone sues the city under a Title II violation because it's a public entity. And it's the plaintiff who has to prove to the satisfaction of the fact finder, whether it's a judge or it's a jury, that that there's a disability, that the service animal was individually trained for X tasks, and it winds up being, just like in anything else in life, subjective determinations of the claimant matter, but you're going to have expert testimony, you're going to have people who weigh this out, and it's going to be typically whether or not the tasks are. Now, I couldn't find any cases about the interference issue or the leash issue. With that, I'm agreeing with DCA that there's not really any kind of guidance out there in the case law, but it winds up, it's not the subjective determination of the claimant to establish a violation. And so that's the tricky part, is whenever day to day on the ground, when people are making the determinations, it winds up being, what do I do to not get my employer, whether it's a city or a public accommodation, sued? That's not necessarily the same thing as saying, what do I do to not violate the ADA? Because you can, the idea is to be over-inclusive and to make mistakes in the non-infringing direction. And that's typically what we hope happens. But when it comes to an actual kind of claim of violation, then you have to remove it from the subjective understanding of the claimant and then have a determination, this task force or a jury or a judge, and say, here are the facts. Here's what, if there are experts, what the experts say about the disability, the nature of it. Those are things you can't ask on the ground whenever you say, is that a service animal? You're limited to 2 questions under the regulations. But whenever there's a claim of violation that goes to court, for example, it's a lot broader than those 2 questions.
Member Josh Wolf and Vice Chair Howard.
All right, 2 quick points. One, I believe either in a previous committee hearing or in the larger body that we did hear from either this respondent or one of the other respondents, speaking of a wheelchair, someone in a wheelchair with a service animal as being an exception that has been granted in the past around a dog off leash. We can, verify that that's what I heard from the respondent, although it could have been the other respondent as well. And I understand where you're coming from in terms of analyzing where the ADA puts the onus on whether or not the animal needs to be on leash, or that whole element. But I think that it's cleaner to avoid that, in that our petitioner that has come forward has said that not having that accommodation made makes City Hall inaccessible, which fits cleanly within the language of 6713A. And so that avoids us sort of second guessing the ADA and just looking at the meetings are inaccessible. He's made a case for that because of his physical disability. That's just the cleanest way to go that I see. So that's where I'm at.
Okay, Vice Chair Howland.
I agree.
Okay. Couple of things more that came up for me is, and also in agreement with Member Josh Wolf, we can make a determination based on a barrier to access of a meeting, just on its purity based upon the Sunshine Ordinance alone. Okay, with or without the ADA aspect to it. And I think there's enough detail in 6713 to provide us with to support that. But also, this can go both ways. We can make a determination here, and then if Mr. Tedesca continues to have issues, he can take our determination and go to court. And the court is going to first ask, well, was there a local process to determine if this is a violation? And then he can comfortably say yes. And here's what the order of determination was. And if we find in his favor, then they'll have it, and the court can then proceed from there to then say, okay, I agree or disagree that there was a violation to access. Now let's work on the detail of the ADA, which is not in our jurisdiction. Or it can work in the reverse. He can go to court and get a determination around ADA, and then come back to us with a court order, or a decision that would help us more easily make a more clean-cut decision. So, based upon that, I'm hoping that maybe that will help also guide us into forming a motion. Maybe Josh Wolf.
I'll go ahead and make a motion, but before I do that, I think that asking the complainant to seek documentation through the court process to bring to us is a large barrier for many members of the public. If if this legal firm that we've reached out to is interested in pursuing that case, that changes everything. But as an individual, I think that's a big ask. I would like to go ahead and make a motion for a violation of 6713A.
There's a motion on the floor for a violation of 6713A. Is there a second?
Second.
Moved by Member Josh Wolf, second by Vice Chair Hyland. Any further discussion on the motion? Seeing none, public comment on the motion. Seeing no public comment, are we ready for a vote? Please call the roll.
Member Wolf?
Aye.
Member Wolf, aye.
Go ahead. I'm
Josh
sorry.
Wolf, sorry.
Use the first. Okay.
Member Hyland?
Aye.
Member Hyland, aye. Member Hinsey?
Aye.
Member Hinsey, aye. Member Kate? No. Member Kate, no. Member LaHood?
Aye.
Member LaHood, aye. Member Kanata?
Aye.
Member Kanata, aye. Member Tesfaye?
Aye.
Member Tesfaye, aye. Member Martin?
Aye.
Member Martin, aye. Member Yankee?
Aye.
Member Yankee, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion passes.
Okay. Done with the case? Okay. Call the next item.
Through the chair?
Yes.
Do you want to refer that to something to see what comes of it, or? I mean, I guess you can do that at any point anyhow.
I'm going to hold off on that until we dispense with the next item. I may go back and refer the previous one. I'll just I'm going to take some liberty as chair to make that referral. Okay, let's call the next item.
Item number 5, file number 18028, complaint filed by Denton Tedesse against the Sheriff's Department for allegedly violating Administrative Code Section 67.5 by restricting access to all meeting of any policy body in City Hall.
Okay, again, we continued this item on December 5th. For more or less the same reason. This case is the respondent is the Sheriff's Department. Okay, and I don't recall where we left off in the case.
Through the chair?
Yeah.
I think this was the following case, and because Mr. Tedesse had to leave in the middle of the previous one, I don't think we got to this one.
Yeah.
Okay. It was continued before. Right. I got it. Okay. So I haven't. Okay.
We haven't heard this yet.
All right. So wait a minute. Did I make a mistake for the previous one? No. We got it up to rebuttals. Okay.
Yeah,
got
we
it.
get to rebuttals.
Okay. Great. Okay. So let's. We're picking this up at what period? I guess in the same place.
No, at the beginning.
No,
at the beginning.
This is a new hearing now.
Got it. Okay.
Yeah.
Okay. Great. I got it. All right.
Want to hear from EOTF on this, or?
Yes. Go for it.
Yeah, so this case came before the EOTF committee prior to attending the full task force. It's essentially the same legal issues, some slightly different circumstances, and a different respondent, but I think that's an adequate summary, actually. Is there anyone from EOTF that was at that meeting on that committee with me that's still on the task force, Eve? Not sure, not hearing anyone piping up. So I think I'll leave it there and toss the mic back.
Okay, great. All right, let's start with the petitioner. You have 5 minutes.
Good afternoon. My name is Denton Tedesse. Again, here's the recording from the Mayor's Office on Disability. This is Donna Atkins, the original person who I had filed my complaints against.
Animal must be under the person's control at all times. Short of that, the person with the disability can be asked if it's
not apparent that the dog is under the person's control, the person with a disability is always allowed into any facility and they may leave the dog outside. Approximately 40 minutes after that phone call, Mr. Tedeschi showed up at our office, very angry, stating that he had been denied entry to City Hall. I went through the two questions that are allowed under Title II of the ADA in terms of service animals, which are the questions that can be asked are you a person with a disability that requires a service animal, and what trained task is what task is the animal trained to do for you? When I asked those questions, he became very angry and said, "You are not allowed to ask those questions." And clearly in the law, it says that is one of the questions people can ask if it's not apparent. His response to me was that the task was nonviolent protection. I tried to clarify that a little bit with him, and so basically he said that it was for his safety to have the animal, and I was still trying to clarify that because I'm not really sure how safety is a task under the ADA for a service animal, and I stated to him it sounded more like a pet. At that point, he became really angry. I said, maybe this conversation needs to be over, and that was the last I heard from Mr. Tedeschi, other than the email following.
Okay, so again, my complaint is regarding SFMTA. It's regarding my housing. It has everything to do with everything that's going on in my life. I did everything that you can possibly think of in terms of as a resident trying to petition their government for redress, to ask questions, to say, why are you doing this? Why, what part of me being on a cable car, and it started with the cable car issue. What part of me being on a cable car, sitting on the outside of the cable car with my service animal, sitting between my legs, looking outside, looking away from people, what part of that is wrong? And if it's wrong, if you believe that it's wrong, I can ask you for reasonable accommodation. A reasonable accommodation is central to ADA. It's there in place in order so that people won't be discriminated against. It's very, it's there for discrimination not to happen. It's there. It's almost a buffer, if you will, before people just sue. It should be a warning to the city that hey, there might be something wrong. Let's look into this. What they can look into it is, will my reasonable accommodation to have her between my legs alter the nature of the service that they're providing me? No. Will it in any way hinder the operations of SFMTA? No, it won't. Therefore, as long as she's under control, you must accept this gentleman's request. They never answered. They ignored me. They created new rules saying that you have to have your service animal on your lap. I said that is unacceptable. You never had this rule. I said that from the very start. They came in front of you and lied to you. The director of transit resigned. One of the reasons that he resigned is this particular case. I am sure of it. I emailed. Now I'm emailing calendars. And I'm finding out that all these other people that I've emailed have resigned. Ed Colbeam, chairman of head of cable car division, resigned all of a sudden. All these people are resigning left and right. It has everything to do with everything. That's it.
Mr. Tedeschi, who was it that was on the recording?
That was Donna Adkins.
Donna Adkins.
From Mayor's Office on Disability.
Are any persons or witnesses provide any facts or evidence on behalf of the petitioner, the complainant? Seeing none, respondent, Sheriff's Department.
Good afternoon, members of the task force. My name is Mark Nico with representing the Sheriff's Department. Is it on? Okay. Thank you. Originally, we did file a response to this complaint from the Sheriff's Department, indicating that as far as the Sheriff's Department's role in this is that the Sheriff's Department was enforcing building management rules. I can't speak to Mr. Tedeschi's history with the Transportation Authority, with the Mayor's Office of Disability, with other departments that he's spoken with and had problems with. I can only address today the specific complaint based upon that one afternoon coming into City Hall and whether or not he was able to enter with or without a leash. I want to make sure that the task force understands I'm not an expert on ADA. I'm not the Sheriff's Department is not the entity or the agency who created the rules for City Hall entry. We are tasked with enforcing those rules. One of those rules is that a service or support animal are allowed into the building as long as they're under control and on a leash. With regard to the ADA issues, there are exceptions to that, and that is when the dog or when the service animal is trained to perform a specific task. For the performance of that specific task, they can be off leash, or for the other exception of if a person is not able to carry a leash for whatever disability, obviously the leash is not required. It is not the rule that as long as the dog is under control, that does not need to be on a leash. And I think there might be a misunderstanding about that on Mr. Tedeschi's part or even members of this task force. Because the dog is under the control, whether it's voice control or other command control, does not mean that that dog is therefore, under all circumstances, okay to be off leash under ADA law and under the building management law or rules. So it's important to understand that distinction. As I understand it, and it's the first time I heard this, the only task the dog was going to do off leash, if I understand it correctly, was to go through security. That was not made known to anybody. And there's no evidence that that dog was trained to perform that task that I'm aware of. If that evidence or if that information is known and can be given to the building management, and that's an exception to this rule, I'm sure that accommodations can be made. But with this evidence that we have so far, and with the facts that we have on this case so far, those really aren't the facts before this task force. The force before this task force is, did the Sheriff's Department deny his entry to a public meeting without any type of just cause? They did not. The Sheriff's Department enforced building rules which have been promulgated by the Mayor's Office of Disability and approved through building management and the City Attorney's Office, and that was their role in this. I'm happy to answer any questions, and I don't believe that the complaint should be sustained, at least to the Sheriff's Department.
Is that all you have?
Yeah.
Okay, thank you.
Thank you.
We'll call you back if we have any questions. Are any persons or witnesses to provide any facts or evidence on behalf of the respondent? Seeing none. Members? Member Canada.
Yeah, I have a question for Mr. Nico. So you kept mentioning the building department's rule, and I'm on page 448 of our packet, and it says just that, be under control and on a short leash or in a carrier. But according to the ADA, it's not and. It's there are provisions for when an animal can be off leash. So my question is, who created these rules here? If the Mayor's Office of Disability, it doesn't seem like an Office of Disability would go against the ADA ruling.
I'm only going by what the rules themselves say. I think it does say Mayor's Office of Disability. If you look at, I'm not sure what page you're referring to. In my response, perhaps it's my response, where it has service and support animals welcome.
Right.
It's a sign.
Yes.
And then there's another sign. My understanding is that that was promulgated by Mayor's Office of Disability and Building Management. That was not rules set forth by the Sheriff's Department.
Okay.
And I believe from my research on this case that those rules are, the city attorney has okayed those rules.
Thank you.
I have a few questions. One is in relation to the recording that we heard that leaves me to want to ask the sheriff a question. In the recording, Donna Atkins said that a person may leave their dog outside.
In that recording?
In that recording. Okay. They may leave their service dog outside. Now, how does the sheriff stand to advise the same thing to the public to leave their dog unattended outside on public property when it's well known that this is against the law in the city and the state?
I can't answer that. It's the first time I've heard that tape. I'm not aware of our department giving that advice.
Okay.
It certainly can be an alternative. I'm just not aware that our department does give that advice one way or the other.
I'll confirm it when I ask the petitioner to come up again, since he would be we would get it firsthand from him. And then the other question was with regards to nonviolent protection and not knowing what that is. And because the ADA specifically states that a dog can be off leash or be used for service for nonviolent protection, not knowing what that is. If a deputy doesn't, this is more of a general question, if a deputy doesn't know how to interpret a law or the law, what are they supposed to do under the department's policy and procedure?
I think under those circumstances, the words that I did hear was that the two questions that can be asked, at least what can be gleaned from those two questions, and then make a decision from that.
Glean from which two questions?
The two questions of is it a service animal and what task is it performed to train?
Okay. And so is it the sheriff's position that it determined that this was not a service dog?
On this specific occasion, I don't believe those questions were asked, but I do know from the interaction on the video that was provided of what happened that there were previous meetings and previous incidents where Mr. Tedeschi did attempt to bring his dog in without a leash, and these questions were, or at least their relationship was known to each other, and this information from the Mayor's Office of Disability was known to the Sheriff's Department of this dog, allowing this dog in without a leash was not going to be permitted.
Okay. I have a couple of more questions. Were you raising your hand? Okay. You were raising your hand? Okay, just a moment. Let me finish some of this line of thought here. Do you have any idea? I'm not trying to determine whether ADA was being violated per se. Just trying to gather enough information so that we all can understand how these processes get determined by the actual people on the ground, and what procedures are taken when there are possibly questions, and whether people actually feel that a question needs to be asked, or whether they can make a determination on the spot. So, I was a little taken aback by Don Atkins' statement that whether to determine whether it was a service dog or whether it was a pet. Okay, whether or not the service dog was performing the service doesn't necessarily degrade it into a pet. It could still be a service dog. May not have been able to perform the duty for that particular person, but it doesn't. If it was let's say it was a guide dog for the deaf, but a person who was handling it was a person with a mobility. Okay, if for some reason a particular function in a particular moment didn't happen, it doesn't degrade the dog into a pet. The dog still is a service dog for the deaf. Okay, so I'm a little concerned about anybody making a statement about a service dog being a pet in that way, or that if the service dog normally does the proper service, but in that moment, maybe because there was a distraction that was beyond the dog's control in the moment, could not perform that function. That's a little bit a different question there. But I'm a little concerned. I just want an understanding is what process are the deputies trained for this particular purpose in making a determination?
Generally speaking, it is that the distinguishing factor of is it a service animal or is it a support animal?
How do you determine that?
The only way you can determine that is ask.
Okay,
I don't think a seeing eye dog is a good example of it. It might be apparent to somebody, but on the other hand, you can't make assumptions about anything either. If there is a question about whether an animal is a service animal or a support animal, it's to ask.
Okay, and if the answer is yes, the animal is a service animal, has proper, markings that it's a service animal, is it then assumed that it's a service animal will be allowed through?
Well, I think the next question is what task is a service animal trained to perform? And then the question is, is it a matter of going 10 steps ahead of the person in a crowded room? Is it a seeing eye dog? Is it some other type of training that the dog underwent to perform a specific task? That evidence would be given, and the decision would have to be made whether that complies with the exception to the building rule.
Okay. Let's see. So the only thing I would say is and this is for everybody, as a person with a disability who usually has a service dog, has had 3 service dogs, and have come into this building and have watched other people with service dogs come into this building from my own observation and my own experience, people generally will drop their leash to go through the security device, the metal detector device, because lots of times leashes have additional rivets or metal that would set it off, so the dog is asked to stay behind and to put into either a stand stay or a down stay or some form of stay while the person with a disability walks through first. And then the dog is then commanded to follow. And then usually if the dog is tethered, then the leash or the tether will be picked up or reattached at that time. And that is the way I've always seen it. I've never seen anybody stopped for that, ever.
No.
In my experience of being in and out of this building for 20 years, with and without metal detectors, even before metal detectors were in this building. So that I just want to offer that because that's what's helping me and guiding me with regards to whether there was a specific incident and what is that incident that caused that to happen, and whether was that a ADA violation or is that something else happening? And I just want to kind of I'm trying to get my head around what that might be.
And that's the way I've seen it in federal and state buildings too, and in airports.
Right, and frankly, Mr. Nico, I'm a little disturbed because you testified that you're not an expert and you didn't claim, but you then went ahead in the same sentence and kind of tried to tell us how we should interpret the way the policy is. So I'm a little disturbed by that.
I don't know what I mean about trying to make you interpret it. It's how I see it, how I understand, and how I've learned through this process of understanding what the rule is and what it's based on, and my discussions with other people about it, that I've come to this position. I'm just trying to share my understanding with you.
Is that the department's position?
For us to enforce the building rules, yes.
No, that wasn't what I asked. You had said that you're not an expert in how to determine whether a service dog is or is not its function, and then you, in the same sentence, you stated that that the way the law should be interpreted, and kind of elucidated that we should think in that way. That's the way we should be looking at it. So I find it a little hard to say I'm not an expert, and then to go ahead and try to tell us how we think it should be interpreted.
I'm telling you how I interpret it, and I preface that with I'm not an expert, so take it for what it's worth. Please make up your own mind.
I understand, but is that the sheriff's department's position, or is that your personal position?
I guess I have to make clear, what position are you referring to?
The interpretation that you're not an expert.
I think, yeah.
Is the sheriff not an expert? Is the sheriff's department not? You're here representing the sheriff's department.
Yes, I am.
So you're speaking in the voice of the sheriff's department.
Yes.
Is the sheriff's department not an expert
In ADA? In interpretation
in this
of ADA
particular
law?
in the context of what you were speaking about not being an expert?
I do not think the sheriff's department is an expert either on interpreting ADA law.
Okay.
And if I inferred some reason that they were, I apologize for that. I want to make sure that the information I'm giving you is certainly on behalf of the department, but my personal knowledge that I'm trying to give you is based upon my own education.
Okay. I just want to be clear because it makes a difference.
Thank you. And
for
thank
us.
you for pointing that out.
Okay. Vice Chair Hyland, I'm sorry. Go ahead.
Just to follow on what Chair Wolf said, the first thing that I found disturbing is Donna Atkins' ignorance of the nonviolent protection. That is right in ADA law. That is a perfectly reasonable explanation. So that I'm going to set that aside. But what I want to point out to for the rest of the members, which you may also agree with me here, is having seen this in similar cases go through subcommittees and this full task force, there's a little bit of a where does the buck stop between MOD and the Sheriff's Department. And we've heard through tape testimony, through other minutes, of how the Sheriff's Department representatives have called MOD for advice. MOD has advised that they can ask 2 questions, but ultimately the subjective determination is at the point of entry by the Sheriff's Department, who is their partners, if you like. And if Ray Hartz were here, he would point out to that and say they're passing the buck. Someone has to take responsibility here of correctly interpreting ADA law. And going back to something you wrote in the minutes of April 18th, 2018, case 10828, you write, the rule states in part that your animal must be under your control and on a short leash or in a carrier. And this is reflected in signage in City Hall. That signage is probably what the Sheriff's Department read and what they've been told to do. However, ADA language clearly states it has an unless clause in there. A service animal shall have a harness, leash, or other tether unless either the handler is unable, because of a disability, to use a harness, leash, or other tether, or the use of the harness, leash, or other tether would interfere with the service animal's safe, effective performance of work or tasks, in which case the service animal must be otherwise under the handler's control, e.g. voice control, signals, or other effective means. So there's a disconnect here between what the MOD is stating as building law and your Sheriff's Department is carrying out. That might not be in our jurisdiction, but that might be something that we can, maybe advise on after this case. But there's definitely, well, they said this and we're just doing what they told us. And you're kind of dodging the responsibility of somebody correctly interpreting the ADA law. That's what I'm seeing. And I'm tired of seeing that, quite honestly, back and forth.
I understand what you're saying as far as what the rules say. I would indicate that the additional questions of is it a service animal and what task is it trained to perform does go to that one
Those
area
questions have been asked. They've phoned in, asked those questions, or asked for advice. MOD phoned back and said, you need to ask these questions. We've also heard that these questions have not been asked because the Sheriff's Department, on other occasions, have not asked those questions, not properly determined whether this is a service animal, and just made it on-the-point decision not to allow Mr. Tedeschi in. And there's a little bit of a history there. In fact, he even mentioned in the previous case where the officer in charge was assigned to another building and kind of carried on that relationship there. So there's a little bit of retraining here, I think, ultimately, and hopefully that's where we'll end up with all this, is that we'll get the law right, and the sheriff's department, who is the arm of that law, on the point, the front lines, carries out that law correctly. So
I appreciate it. Certainly, if there's a disconnect between what the rules are and how the enforcement is being carried out is not consistent with those rules, or whoever is going to be the body to find out whether it's building rules are consistent with ADA, that's absolutely something the Sheriff's Department would be interested in, and as you said, would use that in retraining to make sure the intent and the spirit of the law and the needs are being met.
Thank you.
Member testify.
In hearing that, I hope that whatever occurs on motion for this item, we can include a referral to EOTC, because as the people who are enforcing these rules in different buildings, they have to be properly trained, more so than anyone else, really.
Any other questions for the respondent at this moment? Mr. Tedeschi, I have a question for you.
Thank you.
Thank you. So for the day in question, for this particular case, I believe it was to come to a task force meeting on March 27th?
Yes.
2018?
Yes.
Okay. Did anyone advise you to leave your service dog unattended outside City Hall on that day?
Did anyone advise me? No, they did not, but I knew through the previous testimony of Donna Atkins, through just basic common sense, that I can leave my dog outside if I'm not allowed to enter, say, a store or whatever. I'm going to follow the rules. I'm a law-abiding person. I will leave her outside. She'll wait for me, and I will do my business and go back to her, and I'll carry on with my day. That's, as you know, it's as clear as what I'm supposed to be reasonably act and do on any given basis.
And
Yeah.
just out of curiosity,
Sure.
Is that where your dog is right now?
No.
Okay.
She's not. She's actually at a friend's house. And going back to what happened the last time. Prior to me coming to the task force, I had actually left her at a friend's house, and she escaped through his garage and almost got hit by a car. So that's why she was with me. And although I have several more complaints that I will present to this task force regarding that issue. I have made every reasonable attempts to follow what the sheriff's office has told me, which is they absolutely forbade me to come into City Hall to attend a public meeting with Rosie off leash. And exactly what I'm talking about at that certain point. This has been it's retribution. It goes back through all my other complaints. It has it's personal. It's so personal, the fact that when I was evicted, again, because of this leash rule, all of a sudden it appears at my place of housing. I say that no, she's it's been over 2 years. She's been off leash, no problem. And actually, in that case, there were actually all these other dogs that would just come out of nowhere. And because she was off leash, because she had a ball in her mouth, she was able to escape. And again, it goes back to her safety, the safety issue. And so all of a sudden, I get a court order granting me a stay, a week stay. I get a judge to sign that stay. I paid the rent for that stay. I come to City Hall to show the sheriff's office that paperwork that I have. That the very next day, which is a Wednesday, that they have no right to evict me. I come and of course, we have the same issue. I say, okay, fine. Have them come downstairs, please. Please make a reasonable accommodation. I just want you guys to see this paperwork so that I'm not evicted tomorrow. I honestly, this is from my heart, did not think that the very next day I'll be evicted. I was. The very next day, I go out for coffee. I come back. I was locked out. I think you recognize this. I've been wearing the same clothes since then. I couldn't even get my things. Now, I mean, there's fair, there's due process, there's all that. But, this is because the sheriff's office locked me out of my own house. And so that's why you see this continual kind of destructive ignorance from the sheriff's office that under any circumstance, and which I was here at a hearing, that they will try to cut me off at the legs.
Okay, please wrap it up.
Yeah.
Okay.
Yeah, sorry.
It's all right. Thank you. Are there any other questions for the parties here? Seeing none, should we move to rebuttals? Okay. Respondent, you have 3 minutes for rebuttals, if any.
I think I've answered your questions. I think you know the sheriff's position of the rules as written we enforce. There was nothing personal about the enforcement of these rules. It was purely based on what the sheriff's department understood about those rules. If there's any further questions, I'm happy to answer them.
Thank you. And Mr. Tedessa, any further rebuttal?
Based on Mr. Nico's testimony, to find in favor for the sheriff's office, he should have showed how Rosie was out of control, how she did not live up to that standard of the ADA. They haven't shown that. They haven't shown you any kind of evidence that she is either not qualified as a service animal or nor am I qualified as a disabled person. Again, please find in my favor, and I appreciate your time.
Thank you. Okay, members, it's in your hands. Vice Chair Howley.
Just one thing I wanted to point out that kind of came to me listening to testimony. It's something that Mr. Nico said about there's apparently a video of that incident on February 2018 where they looked at the incident. And then he said in his own words that they did not ask those questions. They didn't even bother. That kind of resonated with me a little bit. So, and what Mr. Tiss just said about they haven't shown that he wasn't a service animal. They didn't show that he was out of control. They're not even following the law from what I can hear in that particular incident. And that disturbs me.
Member Josh Wolf.
Based on the previous hearings of this, nobody's ever made a case that the dog is not a service animal. So if you're assuming the dog is a service animal, there's no need to ask those questions. The issue really seems to be about whether or not the leash clause under the ADA is invoked and how that's being handled. And I see the similarities of this case to be aligned with the same violation of the previous case. And I don't see a reason to waver from that on this.
Anybody else? Go ahead.
To go back, I think what's bugging me is that I think that, if I remember correctly, the building management person says they actually checked in with the mayor's office of disability, which is the right thing to do. And then the mayor's office of disability was apparently that they leave it up to the sheriff's department judgment on the ground. And the sheriff department says, well, we get our instruction from the building management. I just don't think that's a workable way to go forward on this issue for just period. They need to figure something out. That's just an aside.
Or postscript.
Hey, one thing that bothers me, which is it's not specific to the sheriff, but it was in the recording hearing Donna Adkins from the Mayor's Office of Housing advising that a person could leave their dog outside unattended, especially if it's a service dog, which is of some value to that person. Whether the dog was having a problem that day or whether the person was having a problem that day that they couldn't get the dog to perform. It's unlawful in the city to do that, and we know that because of what happened when Mr. Tedeschi was here last, and he did leave his dog outside, and somebody called animal care control and had the dog impounded. So, it's very disturbing to me that anybody from the city would advise somebody to do something, whether Mr. Tedeschi had heard that directly before or not, but just in general to have a city, somebody from the city representing, especially from that department, I'm a little speechless about that. Yeah. Okay. Is there a motion?
Before we do
Vice
that,
Chair Allen?
I don't think Donna Atkinson or the MOD is named in this petition.
There's a separate one against it that we heard.
Yeah.
All right. So I'll retract.
Yeah, that's why I said it wasn't. This is specifically on the sheriff's department.
All right.
Okay. Is there a motion? Yes.
I don't have
Member
a motion,
Martin.
I have one more.
Yeah. In the microphone.
I just wanted to say that when the buildings policy states, however wrongly, a short leash is required and under control, I do empathize with the sheriff's department if they don't want to stray from that. I mean, I can imagine if someone from the department doesn't pay attention to that, lets something through and something happens. I empathize with that. It's just, I think the sheriff's department is also in a difficult position. If they don't have clear instruction, they're a law enforcement agency. They're not generally interpreting things.
But then
Member testify.
we've also heard about how they interpret it differently for different people, according to those task force members that come here with that specific knowledge and experience, Member Wolf and Member Hinsey. So why I would like to give them the benefit of the doubt, and from what you're saying, they have a pattern of not enforcing things equally.
Yeah,
And I would just like to agree with Member Testify that I think education probably here would go a long way.
Yeah, just add another experience. I have spent countless thousands of miles in travel on air flight with service animals, and going through TSA is the ultimate test for, because the laws in the terminal is ADA, but once you get through that security, then it's the aircraft rules, which is completely different. And so on an aircraft, you're allowed any animal. But being in the building as a service animal, the ADA applies. So, and I've seen all different variations on a theme with regards to all different kinds of service dogs. It's kind of like the penultimate place to observe a diversity of things. And the way they go about it, and when I've asked them, like, how do you apply all this? They say, well, we apply it here on this side of the aisle, it's ADA. On that side of the aisle, it's the ACA. Okay, and they explain how it works. And so, as I explained before, it's the same thing. They will actually ask, how would you like to proceed? You tell us how you want to proceed with your service animal. Do you want to hand it off to somebody who will hold it, check the dog first, and then walk through? Actually, they'll say, can you walk through without the animal? that kind of thing. It's all an assumption that the service animal is to the need of that person. If they observe that the animal is not performing the duty that it's asked, or it's acting out, like even in that moment, for some reason, it stepped on a staple and it can't help but to be acting out. It can't tell you what's wrong, but for some reason it cannot perform its duty because it got injured in that moment. They could pull the dog off to the side and say this animal's not performing its duty. But then you got to have an opportunity to check and to kind of correspond to that. To determine what the issue is. So there's a lot more care that is taken in with regards to the handling, and I think to me that's what's reflected here. That's why it seems kind of odd for me that this situation would come up like this, having seen somewhat the leniency in this building to allow service dogs to come through of all kinds. And if you have, and frankly, the city has actually it's a state registration for assistance dogs. They call them in the state, they call them assistance dogs, but it covers the gamut for all kinds of service animals. So I just find it very concerning to me. I'm not going to. There are other words I could use, but to me, that's where I want to stand. Member Josh Wolf, then Vice Chair Howland.
Just one last quick point. I just want to kind of get this into the record. And again, it's a disconnect between MOD and the Sheriff's Department on that last, and specifically to what Donna Atkins said about, well, you can leave your dog outside. At the last meeting where the petitioner had to leave, it was an officer of the Sheriff's Department that called in that pickup, and the dog was taken to ACC. That is in the public record. It's also in the public record that Mr. Tedeschi would have had to pay $105 to retrieve his dog. I just wanted to note that in the record for future cases.
I'll go ahead and make a motion in just a second, but I do want to caution, while I agree that education is necessary to resolve this issue moving forward, I don't think it's education on the Sunshine Ordinance, it's education on ADA, and so I caution whether the Education and Outreach Subcommittee is actually the right entity, because it's not education on the task force the way I see it, it's education on ADA issues. At the same time, I do see a violation, and I would like to go ahead and make the same motion I did earlier of a violation of 6713.
I'll second that motion.
Okay, so moved by Josh Wolf, Member Josh Wolf, second by Vice Chair Hyland. I just want to, if you could just base it, if you can base your motion on, is it on the interpretation or the conditions around ADA, or is it just purely that there was a restriction as based on 6713?
Under my read of 6713A, give me 1 second to go back there because I wasn't quite prepared to do that right now. 1 second. That the Sheriff's Department acts as the gatekeeper for the building by refusing to make the meeting accessible to a person with physical disabilities through the accommodation of their service animal in the process they need. There was a violation of an inaccessible to persons with physical disabilities, similar as before. While that's, while there is a correlation to the ADA, I'm looking at this specifically in terms of the language within the task force or within the Sunshine Ordinance of inaccessible to persons with physical disabilities. The circumstances led to the meeting being inaccessible to the complainant by actions that the Sheriff's Department was involved in.
Okay, thank you. Let's get public comment. Any other public comment? Okay, any other debate on the matter? Shall we vote? Please call the roll.
Member Wolf?
Aye.
Member Wolf, aye. Member Highland?
Aye.
Member Highland, aye. Member Hensy?
Aye.
Member Hensy, aye. Member Kate? No. Member Kate, no. Member LaHood?
Aye.
Member LaHood, aye. Member Kanata?
Aye.
Member Kanata, aye. Member Tesfaye?
Aye.
Member Tesfaye, aye. Member Martin?
Aye.
Member Martin, aye. Member Yankee?
Aye.
Member Yankee, aye. The motion passes.
You didn't call me.
Chair Wolf?
Aye.
Chair Wolf, aye. I apologize.
Item's approved. Okay. Let's call the next item.
Next item is item 6, public comment.
Oh, I'm sorry. Please. I want to recognize the call for referral to EOTC. I am curious about your point, Member Josh Wolf, about and I somewhat agree with that. But I think it would prove to be good service even for us to learn that maybe if you could call in an expert or even call in the Mayor's Office of Disability to have them explain how this all works and how it's supposed to work.
I mean, my concern around taking that approach is that I don't think we actually are in a position to get clarity around the way the ADA is written on this matter. I believe that at the end of the day, the appropriate protocol was for someone to file a lawsuit and for it to work its way through that process, because this is sort of an it's an unlitigated issue, as best as our legal counsel has advised.
So let me ask you then, in the spirit of Member Tesfaye's suggestion to refer this to EOTC for training or monitoring, do you see any value in us doing that?
I think it makes more sense because the ADA is not under our purview. It makes more sense to address it through compliance and amendments, that if it's not fixed, making sure that they come under compliance, because I don't think we're actually in a position to educate them so much as we've used our research and role to draw a line in the sand, but that line is not really necessarily built on the ADA. It's built solely on this one clause.
Got it. Vice Chair Howland?
I think I'd agree with Member Wolf there, and I'm wondering if we can go a step further and perhaps couch it in the way of maybe if we write a letter from the chair perhaps to MOD and say we sense there's a disconnect.
Okay,
this is your purview. However, we're going to continue it to CAC just to monitor.
Okay, so how about this? Instead of I don't want to have protracted discussion on it. I just want the question is do we want to monitor it or not, and what's the appropriate committee for that? Member Josh Wolf suggests that we do it through CAC. I want to ask the chair, Member Kanata, if that's something you feel is appropriate. Well, and then I'll ask if Vice Chair Hyland wants to make some recommendations for them to look at. We can make that part of that. I'll make that part of the.
So I think it depends on what the monitoring is. What I'd like to see happen, and maybe it's a combination of education and monitoring. I mean, at least have the Mayor's Office on Disabilities have building management change the signs. If the Sheriff's Department's saying they're following what they're told to do, the signage should reflect what the ADA really says and not what building management has determined they want to say.
Mm-hmm. Okay. All right. So is that a yes or a no?
That's a yes, sure.
Okay. Great. And so then I'll take, if you have a recommendation for what you want CAC to look at.
It was pretty much what Chair Kanata said in a nutshell, but we can maybe include that in the language to them, inviting them to the next stage.
Okay. So then I'll refer this to both cases. I'll refer it to Compliance and Amendments Committee, and I think maybe just if you could even ask, it's almost a sunshine request for for them first to request, I guess maybe notify them of this issue, and just monitor it, and however you see fit, take it from there. Okay. All right, great. Let's move on to the next item.
Next item is item 6, public comment. Members of the public may address the Sunshine Ordinance Task Force on matters that are within the task force jurisdiction, but not on today's agenda.
Okay, any general public comment?
Good evening, Peter Warfield, Executive Director of Library Users Association. We've been coming on and off to the Sunshine Ordinance for quite a few years. We've probably filed dozens of complaints and been successful with most of them. So I'd like to express some concern with respect to what I consider changes to the public complaint procedure that seem to be recent, at least in relation to the last time we filed complaints. We've also, I think, spoken on some of these issues while the complaint procedure was in progress. And so the first thing to be said is that the playbook that I think the public can expect to go by is what the law requires, which is a very prompt hearing in front of the task force. So Section 6721 says if the custodian refuses, which is to say anybody with access to a record doesn't provide what a person thinks is due, the person making the request may petition the Sunshine Task Force for a determination whether the record requested is public. The Sunshine Task Force shall inform the petitioner as soon as possible and within 2 days after its next meeting, but in no case later than 45 days from when a petition in writing is received. And the task force is to inform the petitioner of its determination whether the record requested or any part of the record requested is public. Where requested by the petition and where otherwise desirable, this determination shall be in writing. Upon determination that the record is public, the Sunshine Task Force shall immediately order the custodian of the public record to comply with the person's request. If the custodian refuses or fails to comply with such an order within 5 days, the Sunshine Task Force shall notify the district attorney or the attorney general, who may take, and so on and so forth. So there are very short timelines here and a very strong sense of promptness. I said earlier, it's generally said justice delayed is justice denied. And I think there are a number of points in the procedures that basically make it difficult or impossible to get that reasonable speed. What to include with the complaint leaves it up to the administrator whether a complaint will even be accepted. The maximum of 2 hearings per meeting is, I think, very problematic and basically sounds like it says wholesale, you can make wholesale violations, and it might be many, many months or years even before those are heard. Those are 2 concerns that I have with respect to slowing down the process and also making it much more burdensome than previously for the public. Thank you.
Is there any other further public comment? Seeing none, public comment is closed. Please call the next item.
Item number 7, file number 18001, complaint filed by Julian Sarkar against Jose Cisneros and the Office of the Treasurer and Tax Collector's Office for violating Administrative Code Section 6721 by failing to respond to a request for public records in a timely manner. I just want to say that Mr. Sarkar got in touch with us last week and said that he would not be appearing today, and he had said this at his last appearance that we could proceed without him.
Okay. Is everybody comfortable with that? Okay, great. Okay.
Yeah, so Mr. Sarkar definitely said at the Compliance and
Canada.
Amendments Committee that he was not going to be here. So this has been in front of a few committees, the full task force, and in October, the full task force determined that the records were public and that records that were not produced should be produced even if they were redacted. And the example of that was Member Josh Wolf had brought up the fact that there was a spreadsheet that the complainant wanted access to. And even though all the information on that spreadsheet could be redacted, the fact that the spreadsheet was a public document and the fact that seeing a redacted spreadsheet, numbers of columns, number of rows, at least provides some information. At the Compliance and Amendments Committee, the respondents said they would not produce any further information, redacted or not. So that's where we stand.
And according to the notation in the agenda, you're making a recommendation the matter be referred to the DA or AG?
We have this body determined that they should produce this information, and they have not produced it. So
Okay.
I don't see any other way.
Okay. All right. Yeah. Sorry, Member Joshua.
Just to understand where we're at, this isn't really a hearing. It is to follow up on this matter. So, yeah, I like our process isn't necessarily like 5 minutes where we don't have the complainant here. We're at a
Correct.
different.
We've already adjudicated this case.
Yep.
Right.
It was referred to committee for compliance, and now
Yeah.
we're hearing it back. Is that correct?
And we're sending it back here because the respondent's department did not comply.
Did not comply. Okay. So this is it. This would be for further determination on how we should dispense with this case.
Correct.
Okay. Member Joshua, if you have anything else?
That's what I wanted to speak to.
Great. All right. How should we? So recommendation has been made that this be referred to the district attorney or the attorney general for enforcement. We do have another way to do that. We could send it to the Ethics Commission under the new rules, and they will put it through their discovery department, and will confirm or not confirm our findings. And then send it with our recommendation to the Ethics Commission for enforcement. So you have a number of different avenues here.
Yeah, I'm personally, I'm fine with any avenue. I mean, the getting the information, even if it's redacted, to the complainant is what was determined. So how we
Okay.
go about that is up for discussion here.
Okay, great. Go ahead. You can make a motion for whatever you desire.
And are we going to hear from the respondent about,
Would you like that?
yeah, I think I'd like to hear not hearing what happened and what was discussed at the committee level. I'd like to know why those records
Okay.
were produced.
Is the Office of Treasurer and Tax Collector's Office a representative? Yeah, thank you.
Good evening, everyone. It's Teresa Buckley. I'm the custodian of records and also the tax collector attorney at the Office of Treasurer and Tax Collector.
Okay. Member Kate, go ahead. In the microphone, please.
I just would like an update or an explanation of why the records weren't produced, in the redacted form that I guess the office believes that the information is not disclosable, but why the records weren't produced with the redactions applied.
Sure. So our review of the Business and Tax Administration Code for San Francisco, Section 6-22.1, or maybe says that all information provided to the city from in a tax return or about a taxpayer is confidential based on our review of that code section, which governs everything we do in our office, and a review of the records at issue. We determined that merely redacting the information, but still providing it in blacked out form, would still reveal confidential information. So we cannot comply with the request.
If I may, how would redacted information reveal confidential information?
By the size. So that's been our determination, whether it's a large amount of data or a small amount of data, that people could reveal who the provider of the information was, and that would compromise the confidentiality of the party that gave us the information, and we cannot do that under our governing law.
So it's the number of black boxes or pages of black boxes would somehow reveal information based on the nature of the request and the number of black boxes. Sorry about that, sir.
Sorry, I didn't mean to interrupt. Yeah, so where our review of the information, and based on my experience, I'm an attorney. I have a lot of experience providing records in this context in privilege reviews from prior practice before I came on board, is that it's not just always the information contained underlying, the magnitude, the amount of boxes, as you say, could lead an enterprising person such as yourself, a journalist, or someone else to kind of put the pieces together and figure out who it was and potentially reveal who the provider of the information was. And for that reason, we concluded that we could not comply with the request to provide a redacted version of the records.
And I'm forgetting the facts here, but how many entities were submitting information that were subject to the request?
I can't answer that question.
I have a question. So I hear you making a claim under specific statute. It's not dissimilar from other statutes under the Penal Code or other investigative or other protected, where information of certain nature is to be protected. But we do see in those other areas some documents for file on a particular entity or person or persons to be quite large, and they're completely redacted. And so why would that entity not think that would be compromising in some way for the public's right to know of a public document? The question is whether for us is the information public, and if there is a reason for information not to be revealed, the record cannot be withheld unless the law specifically states that the actual record itself, like in an investigative matter, the actual file, the whole file cannot be can be withheld. Okay, that's the actual medium that it's on and the writing that is in it, the context. But in all other aspects, unless the law specifies that the actual record can be withheld versus the information on the record to be withheld, that's the distinction that we make. That is why there is redaction, because the record itself cannot be withheld because it's public. It belongs to the people.
We're going to have to agree to disagree on your interpretation of the law. Section 6.22-1, confidentiality of the Business and Tax Regulations Code states, Section A, the information in a taxpayer's return is confidential, as is any information the tax collector learns about a taxpayer's business from the taxpayer or in response to the tax collector's request for information made under Section 6.4-1 or 6.5-1, information regarding the tax collector's investigation of a particular taxpayer, including the fact that the tax collector had sent a request for information to a particular taxpayer or is investigating a particular taxpayer, is also confidential. We believe That is not simply enough to black out the black boxes. That would reveal information that under this statute is confidential. And that's why we do not believe we can comply as directed.
Okay, I'll hold my next question. Member Josh Wolf.
I feel that we're getting dangerously close to sort of rehearing the case. So if I guess through the chair could address Mr. Kanata.
Sure, so goes for it.
I'm looking at 6721D. Are you familiar with that section of our...
Not off the top of my head.
No
but go
worries.
ahead.
So this is the part I believe that you're using to refer the issue to the district attorney or the attorney general.
Correct.
And so I just want to walk through, who in your mind is the supervisor of records? Because that's always a confusing term to me because it's not defined any. Is that this body?
Oh, wait a minute. That's Section D is specific to the supervisor of records, which is the city attorney. There is another section. It's Section E. Upon determination, halfway down, upon determination the record is public, Sunshine Task Force shall immediately order the custodian of records of the public record to comply with the person's request. If the custodian refuses or fails to comply with any such order within 5 days, the task force shall notify the district attorney or the attorney general, who may take whatever measures he or she deems necessary to ensure compliance with the provisions of this ordinance.
Okay, so the question is, have we made that order for them to turn this over?
Yes, at the last full board meeting.
And have they complied within 5 days?
No.
Therefore, shall...
That's why the CAC came forth with the recommendation, because it does say shall.
Right.
It doesn't say could.
So it seems to me that it is the onus of this body to fulfill a motion referring this to, let's see, does E define whether it's the district attorney or the...
It's the district attorney or the attorney general.
Or maybe a parliamentarian can tell us whether we have the decision on that or how that works, but...
We have the decision.
So it seems like the only decision we really have before us is whether to refer this to the district attorney or the attorney general, because all of the pieces have happened to get us to this point where it is shall do this.
Correct.
Okay. What's your pleasure?
I'll make a motion that we refer this up to the district attorney for compliance.
Does anyone have any thoughts of attorney general versus district attorney before we get a second on that motion?
Well, I would suggest debating it in the motion. If you feel that it should be other than what the motion says, then you can amend the motion.
Well, I was seeking whether anyone had any insight into one versus the other.
We've done this once before in the couple of years that I've been on it, and we decided to do it with the district attorney because of the local enforcement.
And the district attorney referred it back to ethics, if I remember correctly, right?
I believe so, yes.
So I see an argument to actually take the attorney general approach, but based on past experience. But I will, allow the motion to move forward if someone wants a second.
So there's a motion on the floor by Member Kanata to refer this matter to the San Francisco District Attorney. Is there a second?
I'll second.
Second by Member Martin. Okay, any public comment? Thank you, Ms. Buckley. Any public comment on the matter?
Peter Warfield again. I'm not a party to this complaint and don't really know what the details were, but I certainly agree with Member Josh Wolf, and that is if you've reached the conclusion that there was a violation and you've come to the conclusion that it needs to be sent forward, I think it should be sent forward. I think the question that was asked was very good, and that is, what is the experience of this body with respect to forwarding things to any one of these folks that is in your list of options? So I think that is a very, very germane thing to discuss. Where are you most likely to get traction, if you like, when you refer this? And for that matter, is the or an exclusive or an inclusive or? In other words, cookies or cake sometimes means both cookies and cake. But whatever you decide, I think the discussion is very valid to have with respect to what has been your experience with these options. With respect to any other matter, I'm very happy to hear that this is where it stands and that you seem to be willing to send these things forward. In the past, there have been arguments made not to send things forward because it wasn't effective, that there wasn't necessarily the kind of enforcement, if you like, that you or the complainant would like. And I think that that's something to consider as to where to go. But I certainly don't think that that should be a consideration with respect to whether you send it as your legal underpinnings require. I also think that there's a variety of other reasons for sending things forward, even if it's not effective, because, for example, the complainant may find that useful in some way or another, for example, publicity or with respect to sanctions that might be applied from some other source to the violator, if you like. So I hope that you go forward with a referral and that you perhaps have a further discussion if it suits you over which place to send it. Thanks.
Any other public comment on the motion? Seeing none, members ready for a vote? Please call roll.
Point of clarification: are we sending to the district attorney or the attorney general, or do we?
District attorney.
Okay.
The motion's for the district attorney.
Okay.
You still have a chance to
No, I'm good.
to do something before we vote.
How does the maker of the motion feel about sending it to both the district attorney and the attorney general, given that I know it says or, but I'm not sure that there's a logical reason we couldn't notify both?
I'm fine with that amendment.
I would caution, because the attorney general is going to defer to the local district attorney. That's the reason why the or is in there. If this was a matter that was pertaining or weighted more with the California Public Records Act, in that kind of way, well, this kind of is. I mean, it says one or the other, not both.
Sure.
If you want to go by the letter of the law, so you got to pick one. Let's just leave it at that. All right. Okay. Ready to vote? Okay. Please call roll.
Member Kanata?
Aye.
Member Kanata, aye. Member Martin?
Aye.
Member Martin, aye. Member Highland?
Aye.
Member Highland, aye. Member Hensy?
Aye.
Member Hensy, aye. Member Kate?
Aye.
Member Kate, aye. Member LaHood?
Aye.
Member LaHood, aye. Chair Tesfaye, or Member Tesfaye absent. Member Wolf?
Aye.
Member Wolf, aye. Member Yankee?
Aye.
Member Yankee, aye. The motion passes.
You didn't call me.
Sorry. Chair Wolf?
Aye.
Chair Wolf, aye. Thank you.
Okay, please call the next item. Thank you for attending.
Next item number 9, file number 18079, complaint filed by Ellen Sang against Lily Magis and the Department of Building Inspection for allegedly violating Administrative Code 6721 by failing to respond to a public records request in a timely and/or complete manner.
Was item 8 removed from the agenda?
Item 8
It was removed. It was continued.
It was
I
continued.
got here a little late.
Beginning of the meeting.
Yeah. Great.
Good evening. Can I start? Thank you.
Good evening. My August 16, 2018 immediate disclosure request were for 4 items, but this complaint is for item number 4 only, for all correspondence between DBI staff. On the next business day, respondents failed to produce a single document. Ms. Lily Magis should not be allowed to mix my other IDR requests to confusing or mislead you, me, and the public, because she provide public record to you for my other requests, namely for number 1, 2, and 3, but none for number 4. She also claimed that one email with redacted information between DBI staff, but failed to produce it by claiming it involved staff's privacy. This email is between DBI staff and its public record. It involved the name of the staff, email address, and regarding normal business, a building permit, and 1 location, and for the period less than 1 year. Please order them to produce it, even with a redaction, so that you and the public have an opportunity to review it. You can determine if the email between DBI staff can be allowed to withhold by simply claiming it involved staff's privacy, and why this email that DBI staff use city's email address and time to send email to each other and can withhold it without any proof that privacy was an issue or involved. Ms. Matthews state repeatedly, all records are emails. I have requested them to forward or email record for item number 4, but they refused. Sunshine Task Force email to all parties state that for a document to be considered, it must be received by January 30, 2019. DBI did not submit any document by January 30, 2019. On February 5th, I sent a task force assistant an email informing her that I was out of town on February 3rd, Sunday, and just returned and find out on February 4th afternoon, Ms. Magis just sent 6 emails with many attachments. On August 16, 2018, I emailed my IDR request. On October 12, 2018, I filed Sunshine complaint. On November 27, 2018, first Sunshine hearing was held. For all those months, they failed to produce the records. I cannot reveal so many attachments that they now produce just days before today's hearing to see if they in fact produce the responsive record. Their acts created great pressure on me as senior, unnecessary. They tried to make me to accept their claim they now produce all the record. I ask for continuance to give me a reasonable time to review the record just produced. If not, please order them in violation and order them to produce all the responsive records, including the email they have been withholding. I also want to thank the chair to take up his time to publicly respond and gave me a detailed explanation of the process. When he was informed this newly produced documents and my request for a continuance. Thank you.
I just want to note, just to confirm what she said, I did respond to her. She asked for a continuance just yesterday, and I felt because it was just so close that it really should be our decision, that I suggest that she come forward in whatever testimony that she had to either make the case for continuance, or we'll decide whether that was appropriate or not, whether to proceed or not. So just wanted to, for the sake of transparency. Thank you, Ms. Sang.
Okay, I also want to say that Ms. Sang forwarded to me the various emails that she got from Lily Magis, and I printed all the attachments, and we're talking about this month.
Okay, so let's wait till we hear all the testimony, and then we can start doing a little more discovery on this. Remember, Josh Wolf.
I'm trying to understand whether Ms. Sang is actually asking for continuance right now or not.
She did.
At the very...
She did.
Almost right at the end.
Okay.
She did. Yeah, she asked because she received too many attachments.
Right, I understood why she had asked for a continuance. I was just not sure whether at this point in time she was asking for a continuance or now that she was here wanted to just move forward.
Yes, no, I requested that she come and ask for the continuance because it was so close to the meeting. And because there wasn't an extenuating circumstance except for this particular reason. Okay? Okay, are any persons or witnesses provide any facts or evidence on behalf of the petitioner, the complainant? Seeing none, respondent?
Good evening. Sorry. Lily Magis from Department of Building Inspection. Thank you for your time. I respectfully disagree with Ms. Sang's assessment of the situation. She sent a request on August 16th. We responded the following day, told her that we did not consider it to be an immediate disclosure request because of the files that she was requesting. 10 days later, on the 27th, we sent her a response and told her that all files, including number 4, batch number 4, were going to be found in a CD. She came and picked it up. She informed us that the files, they were voluminous. That's why they were in a CD. There were over 5,000 documents. The reason being was that when we did the search, if there were duplicates, we produced them as the original file responsive to her requests. Shortly after that, she asked us to narrow the requests, which we did to 561 documents for batch 4. We informed her that, again, the files could be picked up through a CD if she wanted to, as she requested. She did not pick the CD up. We then informed her again when she followed up with us for additional documents. Once again, we told her the CD was... we further narrowed the requests again for the files because she was saying that there were too many files. So it went down to 128. She did not pick up the CD, although she was informed that it was available. We further narrowed the requests once again sometime in November before the subcommittee hearing, and there were 69 files in the CD. Because she had told us that she couldn't pick up the CD and she complained about coming to our office repeatedly, we sent her the CD in the mail. I sent the files to the clerk of the Sunshine Task Force. Item number 4, as stated, the files were large, so we sent it via inter-office. And I think the clerk produced all the files. You might have actually gotten the 561 or the 128 pages of those documents. Since then, realizing that she still hasn't gotten the 69 files, we chatted and she said to send it via email. I said the files are too large. One file, I think, is just like multiple megabytes. We figured it out, and basically we did send it 2 days ago. I assumed, based on producing the documents that was all responsive to the subcommittee, I did not need to produce the files once again to the full task force. Was not trying to not produce anything. As you can see, based on what I've already said, we produced the files to Ms. Sang multiple times, further narrowing her requests multiple times, and trying to respond to her requests. Thank you.
Thank you. Are any persons or witnesses to provide any facts or evidence on behalf of the respondent? Seeing none, members? Member Josh Wolf.
Is questions for DBI? What is the largest in megabytes, if you will, that you can send over your email protocol?
Oh, I think probably like, we sent her emails the other day and I looked at one. I think one was 17 megabytes.
Now, the question is, how big does your email provider allow you to send an email?
I think that would be 17 megabytes because one email was 17 megabytes. My colleague tested prior to sending to ensure that the email went through.
Okay, so how big was the 69 files that you sent the CD of in megabytes?
In totality, I don't know off the top of my head. I'm sorry.
No worries. When
Oh, sorry. I do want to say that it wasn't, we weren't able to send it as one email file, but we were able to send it as 6 separate emails with about 10 emails in each file, 10 documents in each email.
Great. And then within your department, if one colleague to another needed to send a large file, maybe from one office that wasn't physically in the space, what is the approach that you guys use to send large files within the office?
Colleagues within the office were all co-located in one building. So if there was an issue, I think they probably would just ask them to come down to their office or put it on a USB or a CD or our drive, actually, our network drive.
I'm just trying to understand why there isn't a protocol in place to put large files online for constituents to download them, as in this case we had a member of the public requesting the documents that her coming to get the CD was a particular hardship. And obviously, I watched a 4K movie on Netflix, so we have the ability to move very large files back and forth without using physical media. And I'm just trying to understand why the Department of Building Inspection hasn't worked out a way to, send a link to the files that's then stored on city server space or using Dropbox. There's any number of solutions available to avoid using. I don't even have a CD drive. If you sent me a CD, I would not have a way to look at it. And so I'm trying to understand, how, as we move away from physical media and most of our computers don't have CD drives, how large files are going to be transferred from DBI to both the public and possibly other city agencies or other governmental agencies.
So you make a really good point about Dropbox and online capabilities. Currently, our protocol for Sunshine records is that we email as we are able. If not, we do produce it on a CD so that we have a record of what was produced. We have not looked into the online capability of using Dropbox or any other share file. As a city agency, we are able to share files among departments through our online Microsoft system, that's only within the agency. Ms. Sang requested the documents through email. We have worked with her in trying to produce the documents in a file that she can open, and in that case, that would be PDFs. And so we hadn't had any problems previously to any of her requests when we produced it in a CD. In this case, we recognize that there were the initial production was voluminous, and we tried to respond to that.
Thank you.
Member Lloyd.
Following in the same vein, I have had similar experiences creating PDFs of lots of files and finding that the size was very cumbersome. Did you do anything to just try to reduce the size of the PDFs, knowing that it might compromise some image fidelity, but just so she could review things and then re-request higher quality images if needed? But it sounds like if it was emails, it was mostly, I don't want to assume, but if she was mostly interested in following text, it wouldn't have to be super high quality PDFs.
Correct. I think one of the files that I had, like when I was reviewing, it was such a big file because there was a bunch of back and forths. The thread was just super large. So in producing it, I'm sorry, I think that's it. Sorry.
I have a quick question.
Sure.
Do you use the next request system?
We do have a next request system. We're part of the pilot group that is part of that.
And did Ms. Sang utilize that?
No, she sends her request directly to us.
And but when you receive a request, does the staffer automatically create a next request file?
No. The way our process is that if we receive the request through email or next request, we respond through the medium that we receive it in, but we don't go back into next request and
Okay.
reproduce it.
Okay.
We do have a different log to account for all our requests, so
Okay,
we wouldn't
great.
need to.
On a different question, hold on, a different question. You testified that when she sent her request, you didn't regard it as an IDR.
Correct.
You converted it into a standard request.
Correct.
Under what statute affords you to make that determination?
Hold on. I have that here. Hold on for a second. Sorry while I search for that.
Take your time.
Our response to Ms. Sang was on, I think this was August 16th, actually, on the day that she actually made the request. We state that although your request was sent as an immediate disclosure request under Administrative Code Section 67.25A, it will require staff to conduct a review of files in order to find responsive records and is not, quote, simple, routine, and readily answerable. For this reason, we're not treating your request as one appropriately filed as an immediate disclosure request subject to Section 67.25, but as one which is subject to the normally applicable 10-day response time.
Hey, I just want you to know that this task force has many, many times, through many departments that have done this, have found them in violation of 6725 for doing that.
Okay.
That does not mean that you get to convert it. What it means, if you continue to read through it, it provides you with the ability to have an extension of time to deliver those documents, to be responsive. Okay?
Okay.
The purpose of, you have to read it through, and maybe it would be a good idea if you want to request it from either our chair for education, outreach, and training, or from any of the members here on what the process is for an IDR. So IDR requires that you respond by the next business day of whether there are responsive records or not. And if there are, and you can provide them, then do so. But if it's voluminous, you can ask for an extension. Okay? But it does not diminish or change or convert that request from being an IDR. The purpose of the immediacy is in the response.
Got it.
Okay? Not necessarily the delivery.
Okay.
Okay? So I would caution you and to caution your entire department not to do that.
Okay.
Especially, are you the PIO?
Yes.
Okay, so I would hold you incumbent to do that because we've taken other departments to task on that, and we don't hear those cases anymore.
Okay.
Okay, so I appreciate that. Okay, any other? Go ahead, Member Joshua.
Do you know what the file size limitation for next request is?
I do not know off the top of my head. We have been using it. Yeah, I would have to follow up.
Are you aware of any situations using the next request that required you to send a CD because it couldn't be attached through next request?
No.
Okay. Is there a reason why, in the event that you have someone requesting not through next request, that you wouldn't just duplicate the file on next request and use that as the storage facility to link them to the documents?
I had not thought about that. Again, as I mentioned, Next Request has been a pilot program in terms of using it. We'll definitely investigate it further in terms of responding to these type of requests.
Great. Thanks.
Sure.
Any other questions? Okay, thank you,
Sure.
Ms. Madges. Should we move to rebuttals? Okay. Ms. Magis, if you have any rebuttals, now is your time to do it. Nope. Okay. Ms. Stang, do you have any rebuttals? Please start. Hold on. Please start the clock.
On August 27th, they did ask me to pick up the CD. And 29th morning, I took the bus transfer and pay the fee and then get the CD. And then when I get home and then find out the first item contains over 5,600 more pages, and the second is 7, and the third was 4. Then I asked them, what page you're referring to my number request. That's why I requested when you responded, give me my number requested, but they refused to respond. So then they said that they have to give me CD. Actually, there's 4 documents. The one actually that finally produced is only two pages. The number 2 is only 2 email. The 5 was 5 email. And then the 4, I know that why they trying so hard, because there's some reason, but not subject to the sunshine as the connections. But anyway, and I just wanted to we have a right to get that by email or by some, because this is all email. They can forward it to me. They can email to me, but they refuse. They make it so difficult. I don't even know. I tell them they don't have to give me duplicated email. Just one would be enough. And also she has not addressed that. You see, did she including the one email she claimed that has a staff privacy issue? No. If she doesn't produce it, it's still not produce all the records. Okay. But I have not reviewed the most recent one. They are from 5,000, over 5,600 to few pages, and then to the number 4 is from over 100 pages and to 65. They can email over 100 pages to Sunshine, and for the other requests, but cannot email the number 4 to me. It's just about on the 4th afternoon, and then she emailed it. I don't have time to review that yet. I just want you to give me a continuous so that I can review. But at least you order her to produce the one she admitted she doesn't. She has not produced. She withheld it because she claimed that there's a staff privacy issue. I have not seen that, so I don't know if that email in fact is involved privacy or have email exist. Just she can claim any email as a privacy or any other issue and not produce. I think that's wrong. Thank you.
Are you through? Are you finished? Okay. Ms. Sang, I have a question. You've come before us asking for a continuance.
Yes.
Do you want us to adjudicate something? If you want us to adjudicate, we're going to continue with the case and not do a continuance.
I have not seen those documents. If it's all the responsive record, I don't know yet. Okay.
Okay. So you want the continuance, even though you're making a claim that there's a document.
Oh yeah,
that is not.
There's a document. She admitted she has not.
Yeah,
produced.
but we're either going to do a continuance or we're going to do adjudicate.
Okay. I think okay. If they don't produce all the response record, then I have to come back.
Well, if you're asking for a continuance, the continuance is to provide you with the time you're requesting because of the voluminous records that they sent.
Yeah.
For you to review.
Yes.
Then we'll have the case. We'll come back, and then you can make your case of what you received or what you didn't receive at that point.
Yeah. I think it would be fair for everybody and to let me have the time to review them.
Okay, fine. Then we'll. The question I'm going to put before the task force is: shall we continue this item, or shall we not continue this item?
All right. Thank you.
Thank you. Okay, members, that's the question before you. Is there a motion or more discussion? Yes.
According to our past continuance practices, we would continue it from the end of rebuttals because we continue it. We start where we left off, and it seems like that's beyond the point. I'm a little confused procedurally here.
I understand what you're saying. She's making a case for continuance. The idea is to get the full aspect of the of what's happening. Basically what the respondent is saying, we delivered everything we have. Okay. Ms. Sang says she doesn't have enough time to do it. She's asking for continuance. If you think we shouldn't have gone through rebuttals at that point, anybody could have stopped it. But we are where we are.
Right. I'm just trying to understand what the mechanism to allow her to share new information she finds if we do continue it, because her last opportunity to speak just happened
I understand.
in this.
Okay, fair enough. If you want to make a motion to continue and to bring the case back to the point of discovery, then we can do that. And then they can have rebuttal. We can redo rebuttal.
I'll go ahead and make that motion.
Second.
Okay, so the motion is to continue the item, and the hearing will continue from the point of discovery after initial testimony and before rebuttal. Clear? Sure. Okay. Moved by Member Josh Wolf, second by Member Kate. Any further discussion? Any public comment? Do you have a question? Well, the point is that it was circumstantial, and what I was trying to ask her is that either we're going to continue the case and not hear subject matter, or we're going to hear subject matter and move forward with adjudicating. And so her choice was to continue the case so she had time to review the documents. And that's the question before the task force now. Okay? Okay. Are we ready for a vote? Okay. Was there any public comment? Seeing no public comment. Okay. Please call the roll.
Member Wolf?
Aye.
Member Wolf, aye. Member Kate?
Aye.
Member Kate, aye. Member Highland?
Aye.
Member Highland, aye. Member Hensy?
Aye.
Member Hensy, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Kanata?
Aye.
Member Kanata, aye. Member Tesfaye, absent. Member Martin?
Aye.
Member Martin, aye. Member Yankee?
Aye.
Member Yankee, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion passes.
I would, if you don't mind, I wouldn't call Member Tesfaye absent. We just had lost her because, she had to leave. I hate for somebody to interpret it as an official absence.
Not present.
I would just say,
They've historically marked as absent if someone's going to the bathroom.
right.
Just for that one vote.
I just wanted it to be clear for the record that I don't think there is a need to I don't think it's need to say it for the record. I think I think it should be notated in the record when the person had left.
She was leaving at 6 o'clock.
Right. So I think it would notate that she had left at that time because all it does is reduce the size of quorum. I think that the idea of absent is just those who didn't show up at the meeting at all.
So no vote or not voting?
It would just
what goes in the column?
I don't know that it's necessary to even have it. I mean, if you want to show who, generally in parliamentary procedure, if you have quorum, you notate who is absent at the beginning of the meeting. Those people that didn't show up at all for the purpose of making or breaking quorum.
And then the people that aren't present just aren't listed.
They just aren't. As they leave, if you start to lose quorum, then somebody, either the chair or somebody, makes a motion that we've lost quorum and now the meeting must end. In that kind of way, it doesn't necessarily. It just notates throughout the meeting who is left. So I don't know. It's because I get a little nervous because we have a specific rule for absences, and if somebody wants to make a case that they left in the middle of a meeting, well, that's an absence, isn't? If you're notating it as an absence, then you must be considering
it. Or if they missed the first vote, even if they showed up and were there for another 4 hours.
Right. Or if they stepped out to go to the bathroom or for some other personal reason, that kind of thing. So I just want to make sure that there's a distinction because it's not even a requirement of me as chair. It's a requirement of the administrator to notify any of us if there has been more than 2 consecutive absences. So and then after that, if after the second one, it automatically gets reported to the Board of Supervisors. So it's a little bit somewhat an automatic process. I would hate for somebody to make a case that, this person left every meeting at 7, this time at 6 o'clock, that time at 8 o'clock, that time at 4 o'clock, at 5 o'clock, that kind of thing.
If you don't want the word absent in there, could we say not in room for vote?
I'm going to check with Victor.
I don't. It's not necessary to. He's standing right there. It's not necessary. I don't. I've in my years of doing parliamentary work, as people left a meeting, it was the vote count notated what the quorum is. All that matters is the quorum. The whoever was absent was only for people who were absent of the meeting completely. And if they came in the middle of the meeting, you would notate for the records that they were present. So that would so you can note the change in the quorum.
Do the minutes? I know the minutes note whenever people come in because I've been late before. Do they note when they leave?
They should.
We could.
I think maybe.
Should.
Yeah.
Yeah.
I feel like that probably doesn't that address the issue of
addresses
whether.
the
And then I
issue.
guess this is something I guess we talked about a couple of weeks ago downstairs in that special
Orientation.
retreat. And I guess it's just defining what an absence is. And I can't recall if we decided or
We're talking
going
about
to amend the rules and we're going to basically make that at the discretion of the chair or make an absence under the provisions mean an excused absence.
Right.
But
we don't have a rule for
Yeah, I believe,
what is excused and what's not.
I believe the Rules Committee is going to take that up.
Yeah. Yeah, that's been a long time. The easy discussion that we haven't had.
But I think in that, I guess I'm bringing that up just because I think in that, with that, any kind of issue about whether I've had too many absences, when it comes up or if it comes up for a vote, whoever deals with that, kicking me off because I've missed too many meetings. We've got the minutes that say Member Kate was at this meeting and left at 6:45, or Member Kate showed up at 6:15, and whether the vote specifically says absent or not.
The concern would come, and it would be something that I would take up with any one of you if you were to leave the meeting regularly at a certain time,
Right.
and you're not fulfilling your duties. And then I would try to address that directly because that's a kind of a little bit different situation. You come just so we can make quorum, and then you leave. Well, that's not really fulfilling your duties, and that's something different. So that would demand a more one-on-one kind of question. So, but I think that notating when if people arrive or leave in the minutes is enough to notate why there was a change in the vote count, and without having to address it or label it as an absent. Because once they leave, but they were here. So it's a little semantical, but it's not unusual that somebody, a member of the public, or some official or somebody would bring it up, or it could be at the time of somebody going up for reappointment that a supervisor has had their staff or have reviewed minutes to determine whether this person's reliable or not, and they see, been absent like 10 times over 12 meetings, and actually they weren't. They had to leave early, and if they could bring it up whether that's a concern. It's happening too many times, but if they've never missed a meeting and then 1 or 2 meetings they had to leave early, that's really no cause for a red flag or for alarm. So I would suggest not using the word or attributing that early leaving or arrival as being, the absent, you be called absent at the beginning of the meeting, you show up, it relieves that absence because it's notated in the record that you appeared, that you arrived. And then the vote counts changed, okay? And so there's no problem. That's the standard parliamentary procedure to do it that way. So I would suggest that maybe we alter that. It's one thing to note that somebody is absent because they've been absent from the beginning of the meeting. But if it's already notated in the minutes, there's no need to reiterate it for each and every count, unless you feel that it's helpful to the public in some way, or to the parties, that they know for every single one, which who was there, who wasn't there. Orders of determination usually also show that who was there, who wasn't there, but the minutes would reflect any decision that was made anyway. So, all right. Well, if we can do it that way, and then if we can revisit it later. If people find it to be problematic, it's really kind of very administrative at this point. Okay. Okay. Let's call the next item.
Item number 10, reports from Sunshine Ordinance Task Force committees.
Okay. So Complaints Committee.
Yeah. I wanted to ask who was going to chair and I spoke to Member Highland about this, who's going to chair the next Complaint Committee meeting.
Right. So we need somebody to step up to chair. Member Tesfaye is stepping down as chair of the Complaints Committee and is joining the EOTC.
Do we have
committee.
a third member who makes up that committee?
Well, how many members are on the committee now? 3, right? So we're losing 1, so we need 1. We need somebody to step up to be chair.
Well, I won't be able to make another complaint committee meeting until May, because I'm going to be out, as I've discussed before, and the one April 23rd, I've got another engagement that's already scheduled.
Okay.
So I'm not going to be here for the complaint committee until end of May.
Okay, so we need another member.
We need another member just to be there. But
right.
In terms of the chair situation.
Is everybody on a committee?
I can substitute for
Okay.
you if you'd like on that committee.
Okay. But we still need a chair. That'll make quorum, but we still need a chair. We still need a chair. Do you want it? Do you want a chair?
Yeah.
It's not that hard, and I think everybody should have a chance of doing it.
And we will be there
hold back
to
now.
assist in the beginning.
Yeah, no problem. It's not as difficult as what I need to do.
I can also step in and substitute for Member Kate as needed.
Okay.
I had a quick question, though, backtracking on our... I know at some point we were piggybacking them. We're not doing that any longer, right? It has its own space in the calendar now.
Complaints?
Complaint meets monthly.
Okay.
Yeah. And I just want to clarify the membership will have Chair Martin. And who are our regular members? Member Kate is a regular, and
Member Martin.
And he's going to step in.
Hold on. Who's the third?
There is no third because Member Tesfaye stepped down, so we need a third. Do you want to serve? Okay. So
I believe Member Yankee will serve as a temporary until Member Kate returns. Yes.
Okay.
So our regular membership will be Chair Martin, Member Highland, and Member Kate, with Member Yankee filling in through May, I believe. Through May.
Or through April.
Through
I'll
April.
be back in May.
Yeah, and he will be back in May.
And just to make sure, that's it's every other month.
That is
No,
monthly.
it's every month, the last Tuesday of the month. Yeah, we've moved all the complaints into the complaint committee unless there's an overflow, and then or there is some specific issue, we will.
Would you like to set a start time for that meeting?
Right
It was 5:30.
Okay.
Right.
And former Chair Tesfa had a hard stop time at 7:30. Do you want to eliminate that or maintain that?
I think let's leave it up to the chair and
Yes.
the members to determine how they want that meeting to go.
Okay.
Yeah.
We will discuss it with Chair Martin.
Okay, great. And Member Tesfaye will be joining EOTC. Okay, you have two members, right?
I have me and Testify. I'm not sure if I have
Well, who else was on your committee?
people that are no longer on the task.
Okay, so it was just you. Okay, so it was just two. Okay.
I kept having to fill in.
Do you want to be a regular member of that?
I'm doing CAC.
You're doing CAC? Oh, okay.
Am I still doing CAC? I think I am, right?
Are you officially on CAC?
Was.
He can be, still be. I mean, I'll fill in. I'll fill that seat for EOTC. Okay. Everybody else has a committee, right? Okay.
And as long as we're talking about this, who are the members of CAC?
Exactly.
So,
okay, that CAC is Kanata, Highland, and LaHood.
And then EOTC is
actually we have a little. I believe we have Kanata. I believe member LaHood and member Hinsey, and I believe that Vice Chair Highland's off the hook for this one.
Happy to be back on the hook if necessary.
Yes, we always need alternates as people are absent.
Well, I was going to say I cannot make the April meeting.
Oh, okay. So that means you're not on a regular committee.
I thought I was still on CAC. I know we
Vice Chair Highland is member of complaints at this time.
Okay. And rules.
And rules.
Yeah, and rules.
Okay, so you're on complaint. Okay, good. And then
And
EOTC will be Chair Josh Wolf, Member Tesfaye, and myself.
Yeah, they think Member Fisher was the other regular member of rules, so I think I'm going to need another regular
two of us
member.
on rules so far.
Okay.
Yeah.
I don't have a committee. I could do rules.
Okay, great. And it meets ad hoc as needed.
We will update our website and distribute that list to all parties.
Okay. Continuing, Complaints Committee, is there anything to report from anyone who's been on complaints? Okay.
I wasn't at the last meeting.
Okay, complaints and amendments. Okay. EOTC. Okay, Rules Committee, is there anything to report?
I think I'll be talking to Victor probably and having a meeting soon.
Okay.
At some point.
Great. And we haven't continued with the Information and Technology Ad Hoc Committee, but we could use an update in the administrator's report about what's happening with the new system. So I'll wait for that to come. Yeah, for the whatever is happening with that. Wait till the report. Okay. Is there any public comment on the reports from committees? Seeing none, let's move to the next item.
Item number 11, Sunshine Ordinance Task Force Chair's Report.
Okay, so we had a fairly good attended retreat and orientation downstairs with lots of snacks that I took home, and some of which I'm still going through. But it was very good. We went over some basic Robert's rules, just about how we run these meetings. We talked about some of the procedures that we work through. We talked about some of the sticking points that the previous iterations, and we continue to have debate and concerns about in the ordinance. And if anybody who attended wants to add to that, if anybody who wasn't there would like to have another one so that they can be in attendance, I'm happy to arrange for that. Okay. Is there anything that anybody still wants to know that doesn't know, that we haven't really covered, that seems kind of unknowing or elusive? Okay. Well, if something comes up, you let me know. We can always have sessions for very specific items If you want to, if you're, I'll give you one example. When back in the, let's see, it probably was 2006 or 2007, when we found out that scanned PDFs were scanning images and not the actual text, and all the metadata was not being saved. We had some experts, third-party subject matter experts that came in that helped us understand how that works. And we'd have a full hearing here with them making that presentation. We've had some on security issues with regards to transparency and stuff like that. So, around metadata specifically. So if you feel like there's something you feel that the rest of us and or the public and or the city family could benefit from, let me know. We can arrange it. You can do it through a committee and then make a report back to the task force to educate the rest of us so we don't have to hear all the gory details in that kind of way. I'm still working on the 2018 annual report. One of the things that we did discuss at the orientation was the effects of Prop B and the how it could affect the Sunshine Ordinance in any kind of way, for that matter. Interestingly enough, in the newspaper this week, there is a call for the banning of face recognition from city used video. So that could be, I don't know to what extent that legislation is still being worked out. It was in the newspapers reported. But I'm wondering if they're going to restrict the use of face recognition and the video exists with the face in it. Okay, the question is this not necessarily blocking it? This is basically using face recognition to connect with other databases and all that. I'm just wondering if anybody feels that there's any concern with regards to Sunshine, with regards to that. Do you see, because now the Board of Supervisors can create a simple ordinance to make adjustments to the Sunshine Ordinance. If you think there's anything to that or not, I'm just throwing it out there because it's based upon Prop B, which is the Privacy First new law, which includes the ability to amend the Sunshine Ordinance. I'm kind of being too redundant, but I hope that was clear. No, doesn't sound like it. Okay. Well, if you find that there is anything that you feel, even potential, I think it's important to report that either in the annual report or even after the report. We should continually advise the Board of Supervisors when we think that there could be any infringement or whatnot.
I have a question, sir. Are you saying we need to think about things like somebody requesting, I want all instances of this person appearing in footage collected by the city, and making visual requests, and then being told no, and then someone coming before us and saying, this is public information, it was gathered, I should have access to it.
So the use of face recognition to perform a request?
Yes.
That's an interesting twist on it. That's very, very interesting. I will definitely make a note of that.
I think I give it 18 months.
Submit a face.
Yeah.
Give me all.
I guess the law would make them unable to fulfill that request without that law.
To fill a well, but the Prop B, if I recall correctly, was specifically around contractors.
Right.
So the question is are contractors subject to Sunshine? Well, in some cases. In a lot of cases, yes, within certain respects. Prop B limits their ability to collect certain data, So if they don't have the data because they've been restricted, then they can declare unresponsive, which would not be a violation at that point. But, okay, it's an interesting point. I'll think about it and talk to you more if I think I need more information. The other thing I was thinking about in that vein was if there was a policy that was created to create a restriction that comply with Prop B, and then the Board of Supervisors then went ahead and amended Sunshine to create an exemption for that particular restriction, and we felt that that would be would be overreaching. That could be the only kind of instance I can think of as to why that section for amending the ordinance would be in Prop B, is because they're trying to create some protection that would then create some lack of transparency that normally would be transparent under state law. And, then that's the question, can they override state law? And I'm not sure where, I'm not sure where that section in Prop B is with regards to that question, if they were to do that. Supposedly they're not supposed to infringe upon the intent of the findings and purposes of Sunshine. So I imagine it can only go in the other direction. But I can see there being some kind of conflict if they wanted to protect the public on privacy first, and then create an exemption for that. So I just keep that in mind. I'm still kind of trying to flesh it out in my own mind how that would work, and if they could do that or not. Okay, so I've asked several times for any input on the annual report. I haven't heard much of any, so I'm just going to continue to do that and then submit it. Okay, and I'll send around the draft. I'll send around the draft. I guess it should be made public before I submit it. Is that kind of how we do it? We kind of, before we submit it, we have it reviewed at an open meeting. Victor?
We probably should schedule it at a future meeting for review and approval.
Okay, so let's do that. I'll have it ready for the March meeting.
And if you give it to us in advance, we can distribute it?
Yeah, I'll get it. I'll have it within 2 weeks. So, okay, great. All right, any public comment on the President's report? The Chair's report. Okay, let's call the next item.
Item number 12, staff report, complaints, and communications.
Proceed.
Okay, I have item number 1, a tentative hearing schedule for 2019. As I discussed with Member Kanata, the Compliance and Amendments Committee has been canceled. The rest of them will go forward. Questions about any of the dates?
Yeah, when is the next CAC?
CAC,
April.
April 16, because next month will be EOTC and CAC and
Okay.
And I will be out of town on April 16th, but I will be here for every other meeting.
That's good. And actually, if that is the one that we're going to potentially have MOD in front of us, I'd like to be there anyway. So,
What time is it still? Is it still the 4:30?
4:30, yeah.
It's at your discretion if you'd like to change it or not.
That's fine.
Okay. Next item,
sorry, what date was that again? April?
April 16.
You're not on CAC anymore.
I'm not, but I might be there for that meeting.
Oh, okay.
And I
Seven.
think he
It's
said-
April 16.
he
That's the
said
next
he wasn't
CAC
filling it.
meeting. Okay.
His member, your member hood's on it.
And if there's a certain item on the calendar, I'd like to be there, but I can cover regardless.
Item number 2, petitions, complaints submitted, hearing files created. We've had 4. Jeff Potter being somebody that Victor and I think is another Trabeau alias.
Jeff Potter?
Jeff Potter versus Arts Commission.
Okay.
Mr. Warfield today turned in his paperwork for his matter, so I'll be sending out a request for information to the library. Monette Shaw is against the city attorney. Mr. Shaw is a reporter. He had submitted a document request to the city attorney, and he feels it wasn't complied with. And then reports of the supervisor of records.
For the reports of the supervisor records, is that what was just presented today?
Yes.
Oh, okay. Continue.
Okay.
Anything else?
Item number 3, pending petitions, complaints before the task force. It's pretty clear.
Just so the chair knows, we are preparing a list of all the items pending before this full task force portion. And as you can tell, there's a couple of months worth of work already in the hopper, along with some other bigger issues that we will be needing to deal with.
Cryptic.
Item number 4, pending petitions and complaints from SOTF to committee. Right now we have 1.
Plus whatever was referred to committee today.
Today, yeah.
Okay, and next.
Pending issues, 3 matters. Well, more than that if you count the 3 from Mary Miles, so it's probably 5.
Okay.
Communications.
Just to speak about this issue, pursuant to our procedures, we have a policy in which if the administrator's office is unable to contact a petitioner or a complainant over several months, we would like to bring the issue to the full task force for consideration of closing all the complaints for this person due to non-responsiveness to our attempts to communicate. We have attempted to communicate with Ms. Trabeau for quite a few months now, and we have not received a response. There's over 30 complaints, and we would like to schedule a meeting at our meeting before the task force to consider closing these matters due to non-responsiveness to communications. Would the committee like to do that? Or would the task force like to schedule that?
Yeah, let's do that. Schedule for the next meeting.
Yes, we will try to attempt to notify the complainant of that meeting, and we will put it on the agenda. And the last item.
I don't know. I mean, you can attempt to try and contact the person if you already have tried to contact them relating to them and you've gotten no response.
We make as many attempts as we can just to try.
Fair enough.
And then we will publish the agenda, and we'll do everything we can to let them know. So if they are still out there, they can try to stop the proceedings of us closing those files.
Okay, thank you.
And the last item is a listing of our communications received by email of approximately 128 and various phone calls and other forms of communications. I believe that completes the report.
Okay. Any questions for the administrators? Any public comment on the administrator's report? Seeing none. Please call next item.
Item number 13, announcements, comments, questions, and future agenda items by members of the Sunshine Ordinance Task Force.
Floor is open. Member LaHood.
I have a question about the email that came out about the Form 700 filings, and there were two sets of dates about information sessions. We would be going to the filer information session, not the filing officer information session. Is that correct?
I'm sorry?
So there are two meetings that say filing officer information sessions, and then there are two meetings for filer information sessions. They are filers, not
You are the
filing officers.
filers. We, as the administrators, are the filing officers.
Got it. Thank you.
Just so everyone else knows, we have an April 2nd, I believe April 1st or April 2nd deadline to submit the 3 forms to the Ethics Commission online. That is Statement of Economic Interest, I believe the Declaration of Sunshine Training and Declaration of Ethics Training, which are due annually. I believe there are 2 members that do not need to fill them out because they were recently appointed.
Thank you, Member Martin. I spoke to them earlier.
They don't need to file them because why?
They filed between October 31st and December 31st. They filed their Form 700, so
Oh.
they don't need to do one for 2009.
Didn't we all do that?
In the year that you're
Else
appointed,
has
you,
to.
I believe the rest of the members filed it last year in April. Our newly appointed members, since they've just recently filed it, do not need to refile for the in this current year.
When we're so I'm a little confused. So when we apply, we send the application form into the clerk, we're requested to submit a Form 700.
That's not a submission to ethics. That's just for the Board of Supervisors review.
So
that's
why-
not an official submission.
I don't. Okay, so I've always had this confusion because I've missed Form 700 filings because of that.
No,
in the past.
the item submitted to the Board of Supervisors is not forwarded to the Ethics Commission.
Why doesn't the Board of Supervisors request the Form 700 on file from the Ethics Commission if it's already there?
It's part of the application process, which says please submit a Form 700 along with your application.
Okay. So I've had this argument before with a previous clerk of the board, before Ms. Cavillo, that under state law, the requirement for Form 700 cannot be used for anything other than for the purpose it was intended for. It cannot be used for collection of information.
If you would like, we'll refer that question to the clerk of the board.
I would, and
we will CC you on that.
I would request that if they want that information, it's public information available at the Ethics Commission.
We will submit that inquiry to the clerk of the board.
Okay, thank you. Okay, anything else for the good of the cause? No? Any public comment on any of the items discussed in this section? Seeing none, please call the next item.
Item number 14, adjournment.
Is there a motion to adjourn?
Sure, so moved.
Moved by Member Canada. Is there a second?
Second.
Second by Member Martin. All those in favor, say aye.
Aye.
Opposed? We are adjourned before 7:30.